The Appellate Division for First Department is now in session. Good afternoon, everybody, and welcome to the Appellate Division First Department oral arguments for Tuesday, September 29th, 2020. I will now call the calendar. The first case is People versus Travis Block. That case is submitted. Second case, Deutsche Bank versus Kirschenbaum. The appellant.
Good afternoon, Your Honor. Michael Falkowski for the appellant.
Okay, you have 5 minutes for argument and 1 minute for rebuttal. The respondent.
Good afternoon, Your Honor. Richard Frankel for the respondent.
Okay, great. You have 5 minutes for argument. The next case is M. Stephanie versus Edgar C. That case is submitted. Next is City Mortgage versus Dalal. The appellant here.
Yes, he is, Your Honor. Jonathan Warner of Warner and Scheuerman for the appellant, Your Honor.
Okay, and you have 6 minutes to argue and 2 minutes for rebuttal. You're welcome. Respondent?
David Gallo of David A. Gallo and Associates for Respondent City Mortgage. Good afternoon.
Thank you. Good afternoon, and you have 6 minutes for your argument.
Thank you.
Next, you're welcome. Next is Lavovsky versus Lavovsky. That case is submitted. Next, Marconi versus Gates Capital. The appellant here?
Yes, Your Honor. George Soteris, Marco and Soteris for the appellant.
Thank you. You have 5 minutes for argument and 2 minutes for rebuttal. And Gates Capital?
Good afternoon, Your Honor. Lawrence Goodman for the respondents.
Great. And you will have 5 minutes for your argument. You're welcome. Next, People versus Victor Gonzalez is the appellant here.
Yes, good afternoon, Your Honor. Jeremy Butt from Milbank LLP, pro bono counsel for the appellant.
Okay, you have 6 minutes for your argument and 2 minutes for rebuttal. And you're welcome. And is the respondent here?
Yes, good afternoon, Your Honor. Kyle Silverstein for the Office of the District Attorney, respondent in this matter.
Okay, good afternoon. You will have 4 minutes for your argument. The next case is People versus Manuel Pena. That case is submitted. Kingston versus IBM Corporation, submitted. People versus Trevor Adolph. The appellant?
I'm Amy Donner, the Legal Aid Society for appellant Trevor Adolph, Your Honor.
Okay, and you have 5 minutes for argument and 2 minutes for rebuttal. And
Thank you.
You're welcome. And the respondent?
Eleanor Ostro for the respondent of the People.
Thank you. You have 5 minutes for your argument. The next case is Archer versus the New York City Transit Authority. Is the appellant here?
Yes, Your Honor. Allison Estes for the New York City Transit Authority.
Okay, you have 5 minutes and 2 minutes for rebuttal. And the respondent?
Daniel Liebersfeld for the respondent, Aneska Archer.
Okay, and you have 5 minutes for your argument. Holmberg versus Bevan Group is submitted. Global Liberty versus Lorenzo. The attorney for respondent Longevity, I believe, is the only attorney that has asked for time.
Yes, Your Honor. My name is Jermaine Koo from the law offices of Melissa Betancourt.
Okay, and you have 5 minutes for your argument.
Thank you.
You're welcome. The next case is People versus Steve Rich, defendant appellant.
Yes, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Steve Rich.
Okay, you have 6 minutes for your argument and 2 minutes for rebuttal. And the respondent, district attorney?
Yes, Ellen Friedman, Your Honor, here for the respondent.
Okay, and you have 6 minutes.
Thank you.
You're welcome. The next case is Ovalle versus Buckwalter. Is the appellant here?
Yes, Your Honor. Joel Celso with Gennarte Gallardo on behalf, on behalf of the appellant.
Okay, you have 5 minutes for your argument and 2 minutes for rebuttal. And the respondent?
Good afternoon, Your Honor. Madeline Shapiro on behalf of respondent Jane Buckwalter.
Great, and you have 5 minutes for your argument. Ildefonso versus City of New York is submitted. People versus Quindell Francis for the appellant defendant.
Stephen Strother, Office of the Appellate Defender on behalf of Quindell Francis.
All right, and you have 7 minutes for that argument and 2 minutes for rebuttal. And
Thank you, Your Honor.
You're welcome. And the District Attorney's Office respondent?
ADA Nicole Nichols for the Office of Darcel D. Clark.
Okay, and you have 7 minutes for your argument. Yaffe versus Shkreli is submitted, and MacArthur versus Fields, the appellant.
Spencer Schneider for the appellant.
Okay, you have 5 minutes, and the non-party respondent, cross appellant, FFO.
Benjamin Bianco, Meister Seeligan Fine.
Okay, and you have 5 minutes for your argument. So this is a good sign. Everybody was here and everybody answered, and I could hear everybody. So I think things will go very well today, I hope. I just want to remind all the attorneys to please keep their microphones muted until your case is called for argument. And obviously, we try not to talk over each other, and certainly you shouldn't talk over the judges, but especially in this format, it's really hard if two people try to talk at the same time. So please try to be conscious of that. We all will be. I will be keeping time on my trusty cell phone. It worked really well the last time, so I have no doubt that it should work today. Okay, if you'll all mute, and the first case that we're going to hear from is Deutsche Bank versus Kirschenbaum. Appellant ready?
Ready, Your Honor.
Okay, you may begin.
May it please the court, Michael Falkowski of Richland Falkowski for the appellant Joshua Kirschenbaum. 2 quick points today, Your Honors, one on the judgment and one on the order of reference. With respect to the judgment, the record is clear that no evidence was submitted either to the referee or to the court with respect to a default or the amount due under the terms of the note. The referee, by her admission, reviewed only a copy of the note, a copy of the mortgage, and the Bratton affidavit. The affidavit itself is not evidence. The affidavit can be used to lay a foundation for the introduction of evidence. Here, no evidence was submitted. On reply, the respondent had an opportunity to submit actual evidence, but they did not. And the Second Department has held that these conclusory affidavits are insufficient to find how much is owed under the note and mortgage, and the referee's report under these circumstances should not be confirmed. And I'm asking Your Honors to follow the Second Department on this issue and hold the same.
Counsel, this is Judge Singh. Is there any argument you're making here with respect to the underlying summary judgment motion, or are you just focusing solely now for the purposes of this argument on the issue with respect to the motion to confirm?
I have one argument on the order of reference. So that was my point on the judgment. If Your Honors don't have any questions with respect to the argument on the judgment, I'll proceed with the summary judgment application and the order of reference.
All right, well, go ahead. If
Thank you.
We're not shy. If we have questions, we'll ask them.
Thank you. So with respect to the order of reference, as Your Honors know, summary judgment is a drastic remedy. It deprives the non-movement of their right to a trial. It should only be granted after the movement makes a prima facie showing of entitlement to summary judgment and eliminates all triable issues of fact.
So why doesn't the Walker affidavit do that in this case?
Oh, very simple, because Ms. Walker does not state that she's authorized to submit the affidavit on behalf of the respondent. She says
refresh my recollection, Counselor. Is there a power of attorney in this case?
There is, but
so why can't we look at the power of attorney as opposed to just looking what's coming out of Walker's mouth? Because, you know, Walker can't create an agency relationship. Isn't the POA sufficient?
No, because what the Walker affidavit does at a minimum is creates an issue of fact. And what we cannot do is reward sloppy draftsmanship, which is what we have here. So Ms. Walker stated that she was submitting the affidavit on behalf of Deutsche Bank as trustee for Fremont. Then the caption was amended to this non-party to be the new plaintiff. And then finally, the respondent admitted its mistake when it moved for judgment of foreclosure and sale, when it asked the trial court to amend the caption non-protunct to reflect the true plaintiff. They admitted that this was a mistake. This was at a minimum an issue of fact, and at best they failed to make a prima facie showing because there is no affidavit from a party here, the respondent. She stated she was submitting it on behalf of Fremont, and that she did not state she was authorized to submit it on behalf of New Century.
But once she submitted evidence of this note and mortgage and proof of your default, didn't you have to do something to raise an issue of fact? Wasn't that enough to make out her prima facie showing, or the bank make out its prima facie showing?
Well, we argue that because she did not state she was authorized to submit it on behalf of the respondent, they did not make a prima facie showing. Alternatively, we raised the triable issue of fact because she states she submitted on behalf of Fremont. Now, that begs the question: is this non-party now the holder, and that's why the caption was amended, or is this just a complete mistake based on sloppy draftmanship? Again, sloppy draftmanship should not be rewarded. Summary judgment is a drastic remedy depriving my client of their right to a trial. They should resubmit.
Any other questions for counsel? Okay, you will have a minute for rebuttal, okay? Thank you very much, Mr. Falkowski. Can we now hear from the respondent?
May it please the court, Your Honor. This is Richard Franco appearing on behalf of the respondent. I'm only going to make a couple points. I want to point out, as we did in our brief, that the summary judgment order was never appealed from, and it's not included in this notice of appeal.
But,
So
we're considering the judgment. So doesn't that bring into play the summary judgment motion as well?
I would argue that it doesn't, because the time to appeal that order is now gone, and the law of the case is that plaintiff was entitled to judgment, and that defense.
I'm sorry, counsel, but is the appellate division bound by the law of the case doctrine? I know the Supreme Court is, but is the appellate division bound by that?
I would argue that it's being raised for the first time on appeal. So in this case, it would be, because this issue was not proper. The right to appeal was not preserved in this case. So without a further order of the court extending that time or otherwise vacating the MSJ, I would argue that the appellate division should not hear arguments on something that's where the time.
Assuming that we were to disagree with you and find that the appeal on the judgment brings up the underlying summary judgment motion, do you want to talk about the merits of that argument?
Well, I think the power of attorney established at the time of the order of reference that party was that the Walker was entitled to submit that affidavit, but the substitution of parties at the judgment stage is pursuant to CPLR 1018 and is permitted, pretty regularly in these cases. And I don't believe that the appellant has presented any evidence that there was a lack of standing or demonstrated that in opposition to summary judgment. So I believe even on the merits, we still uphold the judge, or we would argue that the judgment should still be upheld.
You're muted.
Judge Singh, I can't hear you. You're muted. I think you have a question.
I was on mute. Counselor, so let's move to the Bratton affidavit. Why do you say that the Bratton affidavit is sufficient to grant the motion in this case?
So now we're talking about just the judgment, the JFS motion?
That's right, the motion to confirm.
The affidavit lays out the expenses and itemizes each one of them. It attests to her review of the records, and the
that
court
doesn't attach to underlying records.
No, I said it attested to her review of the records.
That's not my question, Counselor. So then why is it sufficient? Essentially, isn't that a hearsay affidavit, as the Second Department says, or as this department has said, it lacks probative value because the underlying records aren't attached?
I would argue that the Supreme Court, as under CPLR 4403, had the opportunity to grant the motion regardless of that. But you are correct; there are no underlying records attached.
Should we follow the Second Department?
I believe that in this case, there is case law, which I don't have on the top of my head, discussing the fact that there's no evidence submitted in opposition to the motion. In spite of everything being itemized.
Counsel, that goes to that essentially we're talking about the prima facie. Has your client made it out before we get to what the other side has to say about it, right?
We've made a prima facie case for foreclosure. I believe the dispute here now is the amount. Have we proven the amount due? And so in that case, that's what I'm sort of discussing right now.
And
Okay.
and why do you think you have proved it? I mean,
The
just
amount-
based without the referee having seen the documents. Doesn't the referee have to see those documents, not just hear about them, in order to make her findings?
She attests to her personal familiarity with the documents, and based on her sworn testimony of that, and it being uncontroverted, we would assert that that's the only evidence on the record.
All right. Well, I don't think the defendant would necessarily have that, but okay. Anything else, Mr. Franco?
Not unless there's any other questions.
Okay. So thank you very much. Can we just hear you have a minute if there's anything you'd like to respond to, Mr. Falkowski?
Oh, thank you. Judge Singh, you were correct that the prior orders do come up on appeal when there's a final judgment, especially when our time to perfect the order of reference appeal had not yet expired. But just one quick point here, the respondent had the opportunity on reply for both the judgment application and the summary judgment application to fix these defects, and they chose not to. And we don't believe the court should do their work for them. That's it. Thank you.
Okay, thank you both very much. Have a nice afternoon.
Good one.
The next case is City Mortgage versus Dalal. Some more foreclosure cases. Okay, is the appellant ready? You may begin.
Appellant is ready, Your Honor. Jonathan Warner of Warner and Scheuerman to the appellant Link Point Realty. Your Honors, this case is one of a series of cases that this court has now opined on very thoroughly. I would refer to the prior cases in Wells Fargo versus Lieberd, which this court determined in October of last year, and the Wells Fargo versus Ferrato, which it pronounced in May of this year. Both cases, the court has held that.
And this time we actually did follow the second department here. Here we actually have already done that, right?
Yes, Justice Kapnick, you did. You followed Engel and you held that the mere discontinuance of an action does not constitute a deacceleration or revocation. That was the argument that the court below found and denied my client's motion for summary judgment. Now, I don't think I have to belabor that point. There's nothing in this record other than a mere discontinuance. There's no deacceleration letter. There's no monthly statements.
Counsel, this is Judge Singh.
Nothing.
Counsel, the plaintiff's response, in essence, as I understand it, is we're dealing with two separate foreclosure actions, two separate lots. So that line of cases doesn't really apply here. How do you respond to that?
I respond to it, Your Honor, by saying that the bank here has failed to appreciate that it's the note that counts, not the mortgage, and that this note was accelerated in 2009.
And counsel, this was the consolidated note that we're talking about. Is that correct?
That is correct. The 2008 consolidated note, January 15, 2008. Now, the same note was accelerated in action number 1, the 380249 of 2009 case. That, and we know that, Judge, for 3 separate reasons. One, it was admitted to below by the bank's attorneys. They conceded that the note in action number 1 was the same note as the note in action number 2, but they said to the court below that the discontinuance of action number 1 constituted a deacceleration. It was admitted, Your Honor, and you can see the admission at page 197 of the record. More importantly, I say for Justice Singh's question, this argument was not preserved below. This 2 notes argument, I'll call it, appears for the first time on this appeal. It simply was not raised below. It was conceded, the opposite was conceded below. But more importantly than all of that, it's belied by the documentary evidence. It's absolutely refuted by the evidence in the record. The evidence in the record shows that the affidavit of the Citibank employees, both Tiana Roberts and Richard Fernando at pages 219 and 220 of the record, in action number 1, attached the same consolidated note that was attached to the application for summary judgment in action number 2. So I would say to your honors, not only do you have a concession by counsel in action number 2 below, you have a new argument on appeal, which is belied and refuted by the documentary evidence, and it's just a smokescreen.
Counsel, what about counsel, the judge saying, what about the issue with respect to whether it's lot 30, lot 31? Does that change the analysis?
No, Judge, it doesn't change the analysis because you can have a mortgage note that covers 2 separate properties. It happens all the time in real estate deals. You have an indebtedness, and the indebtedness is secured by 2 separate parcels. In this case, City Mortgage chose to accelerate and sue on the same mortgage note in action number 1, the 2009. For whatever reason, and I don't know the reasoning, it only foreclosed on one of the 2 lots. There had been a split in lots. It only foreclosed on one of the lots, 982A. But they accelerated the mortgage and moved, and they proceeded to foreclose on that note. Then they dropped that case in 2011, and in 2016, they move on the exact same note, albeit on a different lot. But this court and the Second Department has always held it's the note that matters, not the lot, not the mortgage, but the note. Once accelerated, unless de-accelerated, the statute of limitations runs. And here, Your Honors, not only do we have the issue of not preserving this argument, we have documentary evidence refuting the argument submitted by the bank itself on its employees' affidavits.
Okay.
And I would ask, under the circumstances, that you reverse the judgment and vacate and dismiss this action.
Okay, thank you, Mr. Warner. You will have 2 minutes for rebuttal. May I hear from the respondent? Mr. Gallo. Mr. Gallo, we're not hearing you.
I forgot to unmute. I'm sorry.
Yeah, that's a standard problem around here. Okay.
All right.
Please,
So
please
it's David A. Gallo and Associates by David A. Gallo for City Mortgage Respondent. It's an interesting argument that counsel puts forward. However, it is my understanding that there were 2 notes executed back in, I think it was May 19th, 2006. Both
but Mr. Gallo, sorry to interrupt you, but even if there were 2 notes, these cases seem to have been commenced to foreclose on one consolidated note. And there was only evidence, as far as I could find, of one consolidated note from 2008. So what does it matter even if there were other notes before that? This was all about the consolidated note.
It doesn't, this is why it's important. I don't know how this was handled by trial counsel, and I hate to start out with something like that.
That's where I want to stop you, counsel. This is Judge Singh. This argument your adversary says is an argument you're making for the first time on appeal. Isn't that a fair statement here?
It's not, because it was made before Judge Barbado, who gave it short shrift and focused on the statute of limitations. And when we made the motion to renew and re-argue before Judge Gonzalez.
But he rejected the argument. He rejected the argument. Right?
He did reject it, but it's part of the record. So it's not like we're bringing it up for the first time now. It was argued that there were 2 separate notes, 2 separate mortgages, and he rejected it. But it was brought up. It's not like we didn't address it. It was brought up, and
let's assume it's brought. But then it goes to my colleague's point: is that from the record, it looks like we're dealing with it's the same consolidated note and mortgage, even if it was brought up. I don't see how you get around that.
Well, the way we get around it was that there were two separate notes. And in the papers, when they talk about the consolidated note, they're talking about the note having to do with premises on lot 31, 782B, not 782A. So perhaps the distinction should have been made clearer. But when they talk about the note, they were talking about the note for lot 31, for premises 782B, not 782A.
So I'm sorry, there's no consolidated note here? I mean,
No, there is, but it has to
and
do.
what does the consolidated note cover in this case?
It covers premises 782B, lot 31.
982B, but who's counting?
I'm sorry, 982B. Thank you. 982B. It's undisputed that there were two notes signed, two mortgages signed, two separate properties, two lots. What's clear is that in the discontinuance on the 982A lot, that the attorney under that index number, which was associated with 782A, annexes the description for lot 31 instead of lot 30. He or she made a mistake. That right there is confusion. Why would you annex a legal description for a lot that has nothing to do with your action? And I think that is why Judge Barbato and Judge Gonzalez said that the record was insufficient to figure out what happened here. That there were two notes, there were two mortgages executed the same day, executed in the same amount, executed on properties that used to be under one lot, old lot 29, and got separated. So the point is when counsel was talking about the consolidated note, he wasn't talking about a consolidated note for 782A and 982A and 982B. He was talking about the consolidated note for 982B, which was lot 31. I mean, there's no arguing that the description in the discontinuance for the first action, the 2009 action, contained the wrong lot. And had that contained the correct lot, I don't think we'd be here today.
Well, it was based upon an order that I think your former plaintiff's former counsel submitted to the judge based upon what I could see. But all right, anything else you want to add?
No, Your Honor, except that there were two loans made here.
All right. Well, thank you. We'll hear back. Mr. Warner, you have 2 minutes.
Thank you, Your Honor. Just two brief points. Justice Barbato held specifically at page 194 and 195 of the record that the two notes in the two different actions were the same. He specifically addressed this issue. And despite everything that my adversary tells to you today, there is nothing in this record that shows that the 2009 action was about anything other than the consolidated note. There aren't two consolidated notes. There's only one consolidated note. And that's the point. There may have been 20 notes in 2006. By 2008, there was just one consolidated note, and they sued on it.
And Justice Barbato seemed to say that the plaintiff, curiously, he noted, has indicated little other than to argue in conclusory terms that the prior action related to a different note and mortgage. So that's how he got rid of that argument, and it was never brought up again. And that was in 2017. That was over 3 years ago that decision was made, correct?
That's correct, Your Honor. But more importantly, the reason he says, I think, uses the word curiously is because they never submitted any documentary evidence with respect to a second note. I mean, they claim here today, and they claim in this brief, it wasn't preserved, as Justice Singh noted, but they never claimed below that there were two different notes in any way that a judge would be expected to respect that allegation. There's no note in the record other than the one consolidated note. It would be one thing if Your Honors were faced with two separate pieces of paper but you're not here. There's just one consolidated note, and Justice Barbato found that it's the same note in the same cases because he looked at the affidavits. They were attached. The affidavit of the Citibank the City Mortgage employees on their application for an order of reference in action number 1 is the same consolidated note as on the motion for summary judgment in action number 2. This argument of 2 notes and we made a confusion is just belied by the record.
Oh.
And it would be a miscarriage of justice to allow them to keep on just pounding the table and yelling 2 notes without ever putting them in front of you.
Okay, thank you both very much. We'll take another look at the underlying documents. Thank you both. Have a nice afternoon. The next case for argument is Marconi versus Gates Capital. Mr. Sitaris, I believe you are arguing for the appellant here.
Yes, Your Honor, that's correct. George Sitaris, Marco and Sitaris for the appellant. May it please the court. So there are 2 main reasons that the lower court erred in granting the Gates defendants motion to dismiss that I'd like to address today. The first one is that the lower court ignored the conduct of the parties and instead relied exclusively on the bond placement agreement, and specifically Section 15 of that, without considering the 9 months of relations and dealings and transactions that occurred between January and September of 2015, when that transaction closed and the bond placement agreement was actually made.
Counsel, I have a question. This is Justice Kennedy, because you have Section 15 of the bond placement agreement. You have emails between the parties. You have the March 2015 addendum. You have the financing memorandum, the 2015 resolution, and as well as Gates's September 2015 invoice, all setting forth that they did not have a fiduciary duty. They were the placement agent. So can you tell me what were the financial advisory services that Gates allegedly, performed that would have fallen out the scope of the fiduciary duty disclaimer? Because it's clear they were the placement agent. Said that in so many documents.
Yes, Your Honor, they were a placement agent, and there's no dispute about that. However, the conduct and the words that they used and the services actually provided, for example—
Where was the evidence? Can you point me to specific in the record? Because I didn't recall anything that there were any services provided that would take it outside of the scope of the disclaimer.
Sure. In the complaint, Your Honor, there are allegations that the Gates defendants attended working meetings where they gave advice, and that's really the crucial factor.
But Counselor, isn't that all part and parcel of providing services? Isn't that just all that is?
Not at all. There are 2 hats and 2 roles, and Gates is the one who set that out in the very beginning. Their first representation to the board was their advisor and bond placement agent. That's in the PowerPoint presentation. That's their own words. They said that, and that is what induced the reliance, the confidence, and created that higher trust. If they didn't show up at that first meeting on January 6th and say, "I'm going to be your advisor," then we wouldn't be here. I agree that would—
aren't Mr. Sitaris, but aren't we bound by the terms of the agreement? I mean, they may have said certain things the day before, but the next day they enter into agreement, they sign it, and it doesn't say anything about financial advisor. And it specifically says, as Judge Kennedy indicated, that there would be no fiduciary relationship. So how do we get to when it's so clear, how do we get to the actions?
Your Honor, there's no document in the record that says there will be no fiduciary relationship until the day of the closing. That's the bond placement agreement. In fact, the letter of engagement that was signed on January 7th doesn't even have a merger clause. It doesn't disclaim any communications that occurred prior. And moreover, you need to disclaim fiduciary duties on day 1. You can't show up on the day of closing 9 months later and say, "By the way, everything that we said and did coming to your meetings, telling you, preparing pro formas, financial models as to how this whole transaction was going to come into play, was the advice. That was what gave the hire relationship. And what the court below did was ignored all of that conduct and just went to one document, which, by the way, the bond placement agreement only addresses bond placement services. It doesn't say anything about advice, which then when you go to the very beginning communications, which were never disclaimed, there's no merger clauses in any of these documents to even wipe out the past history. Then you go back to their original words and they say, I'm going to advise you, dual capacity. And they never disclaim that dual capacity ever. That's clear from all those documents if you really parse through the language. Secondly, you have to acknowledge that there are words and conduct which, independent of these documents, could have given rise to the fiduciary hire trust. The case law is very clear from the Court of Appeals and from this court that the words and conduct matter. You can't just look to a document. There are plenty of cases, and we cite to them on that. But the second point here, which is even as important is the eighth cause of action, which is aiding and abetting, should never have been dismissed. Even if you find that Gates defendants didn't have a fiduciary obligation, the court had no business dismissing the allegations which said Gates knew that one of the other board members at the school, Mr. Acunto, had breached his fiduciary obligations and assisted him in that. That eighth cause of action should never have been dismissed.
This is Judge Singh. A question about that. I mean, I know you make that argument, but how is it possible for the Gates defendants to even know? And so, what's the predicate for that statement that, in fact, the board president is acting without authority?
Your Honor, that's a great question. But there was an August 2015 board meeting, which we plead, where Gates was present, along with the board members who breached their fiduciary duties, and Gates was aware of what was approved at that meeting and what was not approved by the board. And they knew that there was no financing approved up to $77.4 million. The maximum financing that had been approved, as we allege in the complaint, was $70 million. They left that meeting and they knew that there was no resolution authorizing that financing. Instead, they packaged up their private placement memo, which is the most important instrumental document. Because if that private placement memo isn't issued, no bonds can be sold. And instead, they turned a blind eye to all of that, knowing that Mr. Acunto had then signed a certification which is included and packaged up with that PPM and issued it in order to sell the bonds. That is the substantial assistance. It's the indispensable assistance that occurred. And you, even if you want to say that Gates had no fiduciary relationship, which of course we disagree with, and we believe we're correct on that, the court should have acknowledged that at minimum, there's a question of fact that warranted the eighth cause of action to continue. Instead, the court just said Mr. Acunto had apparent authority. I don't know how the court had found that he had apparent authority. There was no evidence in the record. In fact,
he's the president of the board.
Exactly, but we plead.
Doesn't that give him apparent authority?
No, the president can only act within the authority that's given to him. And in this case, there was no resolution saying that he can go and borrow as much money as he wanted. That's certainly not the case. In fact, there were prior resolutions which authorized his limits to that authority. So the moment he turned, and by the way,
why don't you finish up, Mr. Soteris, because you've gone over your time and you'll have a little rebuttal.
Sure.
You can finish your sentence.
Sure. The other point I was just making was the other authority that he certainly didn't have, and there's documents in the record to this effect, that he had signed off on a construction contract in the sum of $15 million and change. He only had authority up to $10 million, and that's in the meeting minutes. And we allege that Gates knew that. In fact, there are specific representations in Gates's PPM, and they allowed that to happen. So they turned a blind eye, and therefore, at minimum, the court should have allowed to survive the eighth cause of action for aiding and abetting. Thank you.
Thank you, Mr. Soteris. Can I hear from Mr. Goodman on behalf of the defendant?
Yes, Your Honor. May it please the court, Lawrence Goodman on behalf of the defendant respondents. It's our position that the lower court properly dismissed all of the causes of action that were the subject of the motion. I think the questioning from the court of my adversary is instructive. There's not just one, but there's a plethora of documents in the record supporting our position as agreed to by the lower court that my client was acting as a mere placement agent in this transaction. It's the BPA, it's the engagement agreement, it's the addendum, it's.
Mr. Goodman, what about the argument that it's the course of conduct that really creates the duty?
And this was raised below, and again, in our view, properly rejected by the lower court. There really is no course of conduct alleged that would take my client from the position of placement agent to something more in the as an advisor, as my adversary argues. As the lower court correctly found, all of the tasks that was set forth in the engagement agreement, and all of what they allege in their complaint, those were all part and parcel of placing the securities on behalf of the school. As the lower court put it, they were all tied to the bond. They didn't necessarily create an independent fiduciary duty, either on the part of the corporate defendant or the two individual defendants. And what you have here, Your Honors, is an arm's length transaction, a board with sophisticated parties on it, represented by able counsel, who ultimately entered into an assortment of agreements establishing that my client was nothing more than a placement agent. And
Mr. Goodman, could you address your adversary's fallback position that, at least with respect to the 8th cause of action, that shouldn't have been dismissed because the Gates defendants were present at meetings and knew, in fact, that the board hadn't granted the approval to the extent, at least, to what the board president did?
Yeah, yes, Your Honor. So in order to state a cause of action for aiding and abetting a breach of a fiduciary duty, you have to have actual knowledge and of that breach, and you have to have a substantial assistance. Now, as to the actual knowledge, as Your Honor pointed out during the course of my adversary's argument, this is Mr. Acunto. This is the chairman of the board. This is the man, the individual who signed one document after another relative to this transaction. And as the lower court properly concluded, he was cloaked with apparent authority. My clients had no reason to believe otherwise. And beyond that, you also need substantial assistance. And in the case where substantial assistance is being alleged against a party who does not owe a fiduciary duty, mere inaction is insufficient. And we briefed that thoroughly. There are cases from this court holding to such effect. So they fail on the two prongs: the actual knowledge because of the cloak of apparent authority, and that reliance on the part of my clients was reasonable. This is the individual who they met. My clients met at the outset in December of 2014. He was the point person spearheading this transaction. He signed every single document from soup to nuts, from the engagement agreement all the way through to the documents that was signed on at closing in September of 2015. So all of the evidence in the record belies any claim that my clients had the requisite actual knowledge to support a claim for aiding and abetting. And then on top of that, I refer to you back to the substantial assistance that was lacking given the absence of a fiduciary duty between the parties. So with that, unless the court has any questions, we've briefed the other causes of action. I just want to additionally point out that in addition to the fact that there's no fiduciary duty on the part of the corporate defendant, there clearly is not against the individual defendants who at all times acted within the scope of their employment with the corporate defendant. And unless the court has any questions, I would just ask that you affirm.
Thank you very much. Mr. Soteris, you have 2 minutes.
Yes, Your Honor. I just want to address the two main points that counsel made with respect to the 8th cause of action. He argues that there was no actual knowledge, but we allege in the complaint that there was actual knowledge of that.
But based on what? I mean, what was it based on? Because that's an unusual situation, claiming that they would know that the president did not have the authority to do what he did.
Sure, there was a specific meeting on August 20th of 2015, which is in the record and pleaded in detail, where Gates was there when all of the key resolutions were passed to enable this transaction to go forward. The one resolution out of the three that came up during that meeting was the actual financing resolution authorizing the $77 million. Gates was there. That was the key resolution they were there for, and to advise, of course, the school in relation to this transaction. They, after that meeting, went forward and issued the PPM based on 77.4 when they knew at that meeting. And that meeting, by the way, was also referenced in the PPM as the date of when this authorization allegedly occurred. So they had actual knowledge. And by the way, most importantly, on a motion to dismiss, the respondents here had not come forward with any evidence to conclusively rebut that. Secondly, as to counsel's argument that mere inaction is what occurred, that's completely out of the realm of possibility here. The respondents prepared hundreds of pages in a document called the PPM. Without the PPM, which we allege was indispensable, and that's not rebutted in any respect, if that PPM was not issued, that's the affirmative action that the respondents engaged in to enable this transaction to go forward, and more importantly, to enable the chairman and president of the board to breach his fiduciary. It's beyond substantial assistance. That's the actual act itself that they engaged collectively with the board chairman. So at minimum, the eighth cause of action must stand, and we would ask the court to reverse the lower court order in its entirety. But at minimum, the eighth cause of action must stand. Thank you.
Okay, thank you very much, both of you. We will take a look and appreciate your arguments this afternoon.
Thank you.
The next case for argument is People versus Gonzalez. Mr. Butt, looks like you're ready to go.
Yes, Your Honor. Thank you.
Okay.
Jeremy Butt from Milbank LLP, pro bono counsel for the appellant Victor Gonzalez. Just before I get started, a quick housekeeping point. We sent the court a letter on September 24th, letting it know that Mr. Gonzalez's sentence is 25 years, not the 26 to 28 that we had said in our brief. So I just want to make sure that the court is aware of that correction.
I think we are. Thank you for confirming that, Mr. Butt.
Thank you, Your Honor. Turning now to Mr. Gonzalez's conviction appeal. The crux of the appeal really comes down to one issue. Would a reasonable person in Mr. Gonzalez's circumstances have perceived that lethal force was necessary to defend himself against Mr. Pinto? The evidence amply demonstrates that the answer to that question is yes. So when we evaluate that question of what a reasonable person in Mr. Gonzalez's circumstances would have perceived, it's crucial that we look both at what Mr. Pinto did that night, but also the relationship between these two men over the preceding year. Because the Court of Appeals instructs that when we're evaluating what a reasonable person in the defendant's circumstances would have perceived, we imbue that reasonable person with the knowledge and the experience of the defendant. So what did Mr. Gonzalez know, and what was that experience? Well, it was nothing short of a campaign of abuse and harassment by Mr. Pinto. Mr. Pinto had degraded and demeaned Mr. Gonzalez. This happened both at work and at home. He had assaulted Mr. Gonzalez. And when Mr. Gonzalez finally built up the strength and the courage to quit his job where Mr. Pinto was his boss, Mr. Pinto responded by brandishing a firearm at him and threatening to kill him. And so all that context, that experience, informs what a reasonable person would have perceived and would have...
Wouldn't a reasonable person have just sort of left the apartment? In this case, my understanding of the record is that your client charged Mr. Pinto, charged into a room, hit him several times with a hammer, and then stabbed him 4 times after that. Is there really a basis to say that there was justification for this continued use of deadly force?
Yes, Your Honor. So to begin...
So it's based on the prior experience?
The prior experience is crucial in evaluating Mr. Pinto's actions that night and how Mr. Gonzalez would have perceived those actions. But that night, Mr. Pinto had launched at least 2 attacks, first breaking a bookshelf over Mr. Gonzalez's back and pinning him down. Recall that Mr. Pinto weighs around 100 pounds more than Mr. Gonzalez. So you have this larger man pinning Mr. Gonzalez down and punching him until he had to be separated.
So how much time expired between when Pinto acted in this manner and the time that the defendant charges into the room where Pinto is?
Somebody froze?
Yeah, I think so.
I'm sorry, I think my connection just got lost. Can your honors hear me now?
Yes. Yes, we can.
My apologies, Justice
That's okay.
Singh.
Did you hear Justice Singh's question?
No, if you don't mind, please repeating it, Justice.
So you say that Mr. Pinto throws a bookshelf on the defendant. I want to know how much time passed between Pinto's actions and the time that the defendant charges into Pinto.
Yeah, according to the record, and we don't know for sure, but there was a period of time, about an hour, that had passed. And during that hour, though...
So I'm sorry, so couldn't the defendant have retreated within that hour as opposed to charging Pinto and stabbing him?
He did retreat into his room during that hour. And when he left his room after an hour to try and take a shower to further cool off, he was again confronted by Mr. Pinto, and it was only at that point that he used the force to defend himself by hitting Mr. Pinto with a hammer.
But then he continued chasing after him and hitting him continuously even after he had fallen down. So, I mean, he didn't have to do that either.
I believe, or in my submission, it was necessary, or a reasonable person would have perceived that it was necessary to incapacitate Mr. Pinto, because Mr. Pinto had confronted and attacked Mr. Gonzalez at least twice, and perhaps 3 times that night.
So in other words, what you're saying is the defendant had the right to take a hammer to Pinto, and after he fell or whatever occurred, then to stab him 4 times on top of that. I mean, it sounds like we're living in the Wild West now.
This was a very horrific and tragic incident, but he did have the right to defend himself with lethal force because he reasonably perceived that lethal force, or at least serious injury, was about to be used against him.
But after, Counsel, this is Judge Mendez, but after Mr. Pinto is already neutralized, he continues to hit him with the hammer. And after he finishes hitting him with the hammer, and now Mr. Pinto is unconscious, obviously there's no threat from Mr. Pinto at this point, then he proceeds to stab him 4 times. How do you explain that? Where is the justification in all these actions?
So addressing the stab wounds, those occurred, as Your Honor points out, when Mr. Pinto was either unconscious or barely conscious. And the prosecution's expert testified that it would have been difficult for a layperson to be able to tell whether he was still alive. And so those
the object was to kill him at this point? The object was not then at this point to prevent Mr. Pinto from attacking the defendant, Mr. Gonzalez. The object at this point was then just to finish him off.
The stab wounds likely occurred during the dismemberment, Your Honor. And that was while Mr. Pinto was technically alive, but Mr. Gonzalez did not realize that he was alive.
Okay, you'll have 2 minutes for rebuttal, Mr. Butt. May I hear from the District Attorney's Office, please? Mr. Silverstein?
Can you hear and see me?
Yes. Go ahead.
Thank you. Good afternoon. May it please the court, Kyle Silverstein for the Bronx District Attorney's Office. This court should affirm defendant's conviction because it was well in accord with the weight of the evidence that disproved defendant's purported justification defense. as the court below credited the narrative that defendant was not justified in continuing his attack. Furthermore, defendant's trial strategy was more of a strategy of mitigation, using an extreme emotional disturbance defense rather than justification. Notably, the court was the one at the court's charging conference to bring up a justification charge. It seems that the defense attorney wasn't even thinking this was a justification. And just to further, for the record, defendant went into his room after a few altercations with Mr. Pinto, had about an hour to cool off. In that hour, in his room, decided that he would take a hammer, conceal it, and if attacked again, would use that hammer. Now, even thereby bringing in deadly physical force at that moment. When and if he met Mr. Pinto in the hallway, he hit Mr. Pinto in the head once. Mr. Pinto ran into a separate room where defendant chased him. When Mr. Pinto was lying on the bed, defendant proceeded to strike him so many times that his skull actually disintegrated almost in the exact same area. After that, he stabbed him 4 additional times, puncturing his lung and heart. And only after that did he then decide he would dismember the body into 9 separate pieces and spread it all over the Bronx. Thereby, the force used was excessive at that moment, and he was not justified in continuing the use of the deadly physical force.
Counsel, this is Judge Mendez. How do you respond to the argument made that the sentence was excessive, given Mr. Gonzalez's lack of a criminal record and lack of a violent record, this being basically his first violent offense?
Your Honor, the sentencing court judge had all the information that defendant relies on, requesting a reduction in sentence at the sentencing. Defendant's attorneys submitted a pre-sentencing memorandum, made these appropriate arguments before sentencing and after sentencing. And the court at that point, after hearing about and seeing the defendant and reading about the defendant, made the decision that based off of the horrendous nature of the crime, that the 25 years of imprisonment was appropriate.
Well, of course, we can look at additional things other than what the trial judge looked at and have to look at that issue. So what about anything that what about these issues? Should we take another look at them? I mean, I know the trial judge had those in front of him.
Your Honor, the defendant is merely bringing up the same mitigating circumstances he brought up at trial. Here, and as this court has held before, yes, you do have the discretion in the interest of justice in reducing the sentence. However, the horrendous nature of this crime, where a defendant hammered the defendant's skull 10 times, then stabbed him 4 additional times, and then dismembered the body and spread it throughout the Bronx, the horrendous nature of the crime, his sentence of 25 years was well within the range and well taken into account.
Any further questions?
There are no further questions. We rely on our brief.
Thank you very much, Mr. Silverstein. Mr. Butt, you have 2 minutes to respond.
Thank you, Your Honor, and I'll focus my rebuttal on the sentencing issue. First, as the court points out, it's immaterial whether the judge below had the sentencing record and whether he considered the arguments that we make on appeal. As this court is aware, you do have discretion and plenary authority to modify a sentence in the interests of justice. And I say that Mr. Gonzalez's maximum 25-year manslaughter sentence is excessive for 2 reasons. First, deterrence and protection or separation from society really don't come into play here. Mr. Gonzalez, this is his first violent offense, and it was the product of a very, very unusual set of circumstances that aren't likely to repeat themselves. He's a very low risk of violent recidivism. Second, Mr. Gonzalez has very strong rehabilitative potential. He's very fortunate to have a supportive family who's willing to give him a stable base from which he is best equipped to successfully reintegrate himself into society. He'll also have access to better mental health supports in a non-carceral setting. So for those reasons, I believe that his 25-year sentence is excessive. Thank you.
Okay, well, thank you. And Mr. Butt, you indicated that you were doing this pro bono from the firm of Milbank, and we want to thank you and the firm of Milbank for letting you handle this case. Thank you both very much.
Thank you, Your Honor.
Have a nice afternoon.
Take care.
Okay, the next case for argument is People versus Adolph. Ms. Donner. Okay.
All right. Thank you very much, Your Honor. May it please the court, my name is Amy Donner, and I represent appellant Trevor Adolph. And unfortunately, I can't seem to figure out how to make my camera be so that I could be fuller in this. So, sorry.
It's fine.
Really, but thank you. Okay, since I know that the court has read the briefs, I just wanted to emphasize, there are a few things that I wanted to emphasize. There should not be two standards of justice for this issue. And there are cases, many cases from the Appellate Division 3rd Department where they clearly vacate the plea in a situation like this, where, as Your Honors know, in this Class B felony, the allocution did not only really gave a single question to the constitutional rights appellant was waiving by pleading guilty. And there was no excuse for this. It was 2 years after Tyrell. The administrative judges in the Bronx and Manhattan had given notice, and in the other counties had given notice to Supreme Court judges. So they knew how to take a plea in a situation like this. Appellate, yes.
Counsel, this is Judge Singh. Why didn't the defendant move before the trial court to vacate the plea? Because there was at least a few months hiatus between the plea and the sentence.
Well, there were. Oh, sorry. Yes, there were. Yes, Your Honor, there were 2 months, and certainly, this issue, yes, it's unpreserved, but the courts have reached the issue in the interest of justice. There are several Appellate Division 3rd Department cases cited in my
What about our department? What about the first department?
No, Your Honor, but what I was, not that I'm aware of, Your Honor, but as I was saying, there shouldn't be two states. It shouldn't be a difference based on whether the defendant is pleading guilty in the, upstate versus down here. That doesn't really make any, it just doesn't seem like that's just. And here, certainly in all the cases cited in my brief, they have, in unpreserved situations like this, they have where appellant is not, they didn't even ask appellant if he had enough time to speak to his lawyer. It was, and certainly, I mean, given.
Could there have been a tactical reason? Could there have been a tactical reason for not going back to the trial court and rather waiting to take your chances with the appellate division?
Your Honor, I have no way to know anything about this one way or another, but I would just tend to doubt that people are really thinking like this. And chances are, counsels, and this was in 2015, 2 years after Tyrell, but certainly chances are any discussion that was between counsel and appellant would have been like on the conditions of this, what he's pleading to, the top count of the SCI and of the top count of the felony complaint, a Class B felony, and chances are they were talking about the sentence and not about any rights.
Well, so didn't the court specifically ask in a colloquy with the defendant, you've gone over with your lawyer the waiver of appeal, is that correct? And he said yes. So yes. So he did, and there was some reference to, did you have an opportunity to speak to your lawyer about the waiver of appeal? And of course, he did execute a formal written waiver as well.
Right, which Your Honor, which has been held is not enough, the written waiver. And certainly in terms of, as I was stated in my brief, first of all, this goes to the waiver. I'm sorry, is Your Honor referring to the waiver of the right to appeal, which of course doesn't apply because this goes to voluntariness?
Yeah.
Or the right, is that what Your Honor is referring to?
No, I know about that. You can go, I mean, you said that he really hadn't indicated that he had had a chance to talk over with his attorney, and the judge did ask him a few times if he did have a discussion with his attorney, because we're supposed to look at, the totality of the circumstances. So, pulling out one little thing or another, we're trying to look through the whole thing as much as we can.
Certainly, Your Honor, but here, and you look in the totality of the circumstances, there were so many things. They didn't tell appellant of the jury of his peers. They didn't tell him about the privilege against self-incrimination. There's no reason to think when he's pleading to the top count of the felony complaint and he's forfeiting $643 that the conversation had anything to do with the rights that he was waiving. They couldn't even get the defendant's name right. I forgot if I said that. So, I mean, this certainly seems like oh, excuse me, Your Honor. I wasn't sure if that was background noise or somebody was asking me a question.
Does anybody have any further questions? Otherwise, we'll let you wrap up and then you'll have 2 minutes for rebuttal.
Thank you, Your Honor. I just wanted to, oh, I'm sorry. Okay, I just wanted to say that there's just nothing indicating that that appellant was told about the rights that he was waiving. And certainly, and there was lots of conversation about other things, even telling him about search and seizure, but in terms of Boykin rights, it was basically one sort of soliloquy that omitted a lot of things that there shouldn't be two standards of justice for. Now, concerning upstate versus here, and also appellant, it's an ideal case for Burwell relief because appellant did so well on probation that probation terminated him. Right. So, and in terms of, and then the other issue in terms of, at the very least, in terms of forfeiture, that the court should remit that the people did not preserve any argument concerning the forfeiture, and it wasn't imposed as a condition of, it wasn't at sentence, and therefore it's just not part of it. And forfeiture for somebody like my client, if it is for it's economically devastating, for a poor person.
Okay, I'm going to stop you now because you've gone over your time. You have 2 minutes for rebuttal. Let me hear from the district attorney's office, please. Ms. Ostrow, is that correct?
Yes, it is, Your Honor.
Okay.
For the people, thank you. First of all, the defendant's claim is not preserved, even though he had ample opportunity to raise it at sentencing. Court of Appeals has said clearly that if the defendant has an opportunity to preserve a claim such as this, he must do so for it to be preserved. I want to note, before just going to the merits quickly, I want to note the second thing is, in his brief, the defendant has stated that even were this court to think that his claim had merit, he does not want the only remedy that he'd be entitled to, which is to have his guilty plea vacated. He has stated in his brief that he wants only dismissal of the case. He's not entitled to that, even to his appeal. That's another reason, just at the threshold, why his claim should be rejected. In fact, however, Your Honor, there is no merit to the claim. The judge carefully did allocate the defendant orally on the fact that he had a right to a trial. He told him that he had a right to confront witnesses, that the proof had to be beyond a reasonable doubt. He also talked about other rights, although he did not mention that the trial right was a jury trial, not the privilege against self-incrimination. The waiver of appeal that Your Honor, Judge Kaepernick noted, in that waiver, it may be that the waiver of appeal does not mean that he can't raise the claim. The waiver of appeal. The waiver of appeal actually went through all the Boykin rights and set forth all of them, and did so because it was advising the defendant that the claims that are automatically forfeited by guilty plea, i.e. the Boykin rights, that there were additional claims. That would happen, automatically, but there are additional claims that the waiver of appeal would therefore apply to. So if you read the waiver of appeal, you actually see that the defendant was advised of all the Boykin rights. He also did have to speak to the attorney. That's clear from the record. The defense attorney said that she had spoken to defendant about all the paperwork. The judge had asked him if the Defense counsel and defendant had been able to speak about the case, and the defendant said yes, also about possible defenses. So under the Court of Appeals law and this department's law, this is a very strong record to support the guilty plea. As for the third department, Your Honor, there are a number of cases where the third department has made certain determinations that frankly are not in line with what the Court of Appeals has said or this court. This court has followed what the New York Court of Appeals has done and has been very careful when they're reviewing all of the records. I'd just like to say one thing about the forfeiture claim. Forfeiture is not part of the sentence, a forfeiture of money. It is therefore does not have to be stated as sentence. It is a part of the judgment. You can see that it was from the record. It also is a claim that's supposed to be preserved. It was not. It's also a claim that can be waived by the waiver of appeal. For all these reasons, Your Honor, we would ask that you affirm the judgment.
Okay, thank you. You have, Ms. Donner, you have 2 minutes to respond.
The only thing that I did want to, since all my arguments are in my brief, I just wanted to say that the people had waived any argument on the forfeiture because they did not object to the sentence. And other than that, if the court has no further questions, I respectfully rest on my briefs and respect that the judgment should be reversed, the plea vacated, and the accusatory instrument dismissed, or at least the forfeiture vacated. Thank you.
Okay. Thank you. Thank you both very much. Have a nice afternoon. Thank you for the arguments.
You too, Your Honor.
Okay, the next case is Archer versus the New York City Transit Authority. The appellant, Allison Estes.
Good afternoon, Your Honors. Allison Estes for the New York City Transit Authority. Can you hear me?
Yeah, we can't see you. Did you want us to see you?
Yes, and
I can see.
You can?
I can.
Oh, okay.
I'm little. I think you can. I'm little, right?
Well, I'm little too, but I mean, I still can't see you, but it's okay. Whatever. Go ahead.
Okay. We are asking the court today to reverse the denial of summary judgment by the trial court. This is a case, the facts actually are undisputed. The plaintiff tripped and fell while alighting from a NELT bus that was 6 inches and by her testimony, and up to 8 to 10 inches by the bus operator's testimony from the curb, even with the street, no defects on the curb. She was coming down the steps, and again, it's difficult from the record what the mechanism of her fall was, but assuming it in light most favorable to her, her foot became wedged between the last step and the 6 or 8 to 10 inches between the bottom step of the NELT bus and the curb, and that's what she says the mechanism of her fall. The proper standard for which to judge a summary judgment motion in the context of an alighting case is there can be liability. We have a duty to provide the plaintiff with a reasonably safe means and place of egress, and liability will not attach unless the plaintiff is required to negotiate a dangerous or defective path in view of the dangers presented.
Counselor?
Yes.
This is the Judge Singh. Could it be argued here that the manner in which the bus driver placed the vehicle, that a dangerous condition was created, and that may be a basis of liability?
Well, there's no evidence that the way that the bus was placed, 6 to 10, at most 10 inches.
So creating a trap-like condition, I think, isn't it the argument that there was a trap-like condition created between the bus and the curb, and that's how the plaintiff fell? Would that be a basis for liability?
Right. There's no evidence that it was a trap-like condition other than the fact that she fell. So in other words, if you look at the cases relied upon by the trial court, Bruno, for example, which the trial court relied upon, the question of fact with regard to the unreasonable safety was that the bus operator knew about the defective condition, and that once the plaintiff stepped out into it, he said, "Oh, you stepped into that hole. Oh, they were supposed to fix that hole." The bus operator in this case did what he does in hundreds of times a week, which is to park the bus within that 6 inches, according to plaintiff, or 8 to 10 inches, according to the bus operator, from the curb, kneeling the bus for extra safety, and opening the door. The plaintiff didn't advise the bus operator that she couldn't negotiate the space between the bottom of the step of the bus and the curb. The bus operator testified himself that he provided her, as he does, with a safe means of egress. So there was no way, there's no evidence that this 6 to 8 to 10 inches, especially in the totality of the circumstances, creates an unreasonably unsafe or trap-like condition. The only evidence that plaintiff presents is...
Is there any amount of space at which it would raise an issue of fact just by the amount of the gap that would be created? Are there cases that say that?
Well, Your Honor, there's the statute that I put into my motion. It's 34 RCN section 4-10C1. And in that rule, bus operators are not allowed to park more than 12 inches away from the curb. But and the trial court pointed out that it doesn't necessarily relieve the transit authority from liability per se, but it is an indication, and it certainly should have been taken judicial notice of. The case that the trial court relied on, Bruno, is again very different. The plaintiff stepped off the bus into and walked into a known defective, dangerous condition and fell. And what the first department held was that it didn't matter that other passengers had gotten off the bus before. What was really compelling to the court was that the bus operator knew about the defective condition and stopped adjacent to it nonetheless. The bus operator in this case stopped within no more than 10 inches from the curb. There was no defect on the curb. There was no snow and ice like the malware case that plaintiff relied on. There's no defect on the curb. It's just the distance. And the distance in the context and the distance in the context of everything else, including the bus operator not being aware that anything that he was doing was creating a dangerous condition, the plaintiff not acknowledging or saying to the bus operator, like in the kneeling cases, look, could you, this is not, I can't negotiate this. And the fact that the totality of the circumstances were as about paradigmatically reasonably safe as they could possibly be, as they are in the general course of transit business. I'm gonna stop you there because you've gone over your time a couple minutes. We'll listen to plaintiff's counsel, and then you have 2 minutes for rebuttal, okay?
Thank you, Your Honor. Daniel Liebersfeld, Franz Blau and Dratch for the plaintiff, Oneska Archer. This is very simple. This is on a motion for summary judgment, and the issue is if there's a material fact as to whether there was, I believe as Justice Singh pointed out, a trap or a snare into which plaintiff's foot got stuck, which caused her fall.
Counsel,
we've identified.
This is Judge Mendez, counsel. Was there anything defective on the sidewalk where the bus dropped off your client?
That's not alleged, Your Honor.
No. Was there
no cracks in the sidewalk or
no cracks in the sidewalk, no holes in the street?
Right. My adversary is correct that the allegation that it's the distance between the bus and the curb. And I will say that I don't think that there's either side pointed out a case.
Wait, let
sorry.
Judge Mendez
Was the
finish.
bus lowered in order to allow your client an easy egress from the bus? The bus
Just
was
one
low.
point, my connection's going in and out, so I might lose you. But according to our client, the bus was knelt. That's
Okay.
not disputed.
And it was not more than 6 or 10 inches away
I
from
think
the
we
curb.
have the record reflects it's between 6 and 10 inches or 6 and 12 inches from the curb.
Okay, so then what is the issue of fact that you say was created?
The issue of fact is whether the bus parked at a distance, stopped at a distance from the curb that allowed my client to alight from the bus safely. And again, just because every other, and this is established in the Bruno case, just because other passengers in the bus were able to alight safely does not require the granting of the motion for summary judgment. And again, all we're saying is that the motion for summary judgment should not have been granted, and that this is an issue for the jury to decide. And if I could just point out the main cases that my adversary relies upon, there are two of them. They're the Trainer case and the Sabella case, and that has to deal with the kneeling of the bus. And the suggestion is that if the bus is knelt, then there's no liability. Or sorry, I'm sorry. It's basically in those cases, it's sort of like an a fortiori argument that in those cases the bus wasn't knelt, and the defendants didn't fall on a specific defect. So the same result should follow here.
Well, we don't have a
But
defect
again,
anywhere here.
it
Where's the
wasn't an
defect?
issue of getting the foot stuck between the bus and the curb.
Where is the defect? That's what I want to know. Where is the defect?
The defect is sorry, are you losing me?
No, go ahead, answer.
Okay, sorry. It's not the unsafe condition. It doesn't necessarily have to, I guess it doesn't necessarily have to be a defect on the sidewalk. The condition is
Counselor, this is Judge Singh. Counselor,
this is Judge Singh. Bus and the curb.
Counselor.
Judge Singh, go ahead.
Thank you.
Yes, sorry.
I understand your argument. I truly do, and I think we all do. But the question is there a case that supports the argument that essentially that by bringing the bus to a particular spot, that in itself creates a dangerous condition? Because the cases generally talk about the duty is to leave a passenger in a place where they can where they don't have to negotiate a dangerous or defective pathway. Right? There's no case that particularly addresses what you're arguing here, correct?
That I would say that there's no case that addresses it either way. There's no case that either side has cited that has said that either way, one way or the other.
Okay, fair enough. So what is the case that most that you believe is strongest in your favor?
Well, I don't think it's a particular, fact pattern. I think the idea is just that the lower court, the motion court was correct, where he said that this was analogous. Didn't say it was, precisely identical, but that it was analogous to a situation where there is a defect on say the, in the path of alighting. And again, it's not, I'm not saying that it's precise, but again, especially in the absence of any, case that says I'm wrong, that it is a fair analogy, especially if we're talking on a motion for summary judgment, where as the standard that the facts are, that every inference is given the benefit of the non-movement.
All right. Anything further you want to state? Because otherwise we're okay.
None on my part, Your Honor.
Okay. Thank you very much. The appellant has 2 minutes to respond if you'd like to respond.
Just very briefly, I wanted to just correct that the record is from the plaintiff's testimony is 6 inches and the bus operator's is 8 to 10 inches. So there's no record of 12 inches. I just wanted to, it's a very minor distinction, but I wanted to make that. Again, the only analogous facts in Bruno and in this case are that the plaintiff fell. And simply because a plaintiff falls and simply due to the mechanism of the plaintiff's fall does not raise an issue of fact with regard to whether or not the transit authority breached its duty to provide plaintiff with a reasonably safe path and means of alighting. And I will rest on my briefs, and I thank your honors very much.
Thank you both very much for your arguments, and have a nice afternoon.
You too.
The next case for argument is People versus Steve Rich.
Good afternoon, Your Honors. Stephen Strother from the Office of the Appellate Defender on behalf of Steve Rich. Your Honor, Mr. Rich's case should be reversed and the indictment dismissed because his conviction was based on legally insufficient evidence as it was against the weight of the evidence. The vast majority of the evidence in this case had no probative value as to whether Mr. Rich entered an agreement into an agreement to be a part of Angel Alvarez's drug organization.
Counsel, this is Judge Mendez. You said the vast majority, but isn't there evidence in the record that shows your client taking steps?
So, Your Honor, there's only one piece of evidence that the prosecution, I believe, can legitimately rely on, which is the fact that Mr. Rich placed a bag into the back of the trunk. But however, we think that if that evidence is interpreted consistently with the other evidence, it's not indicative of his intent to join the conspiracy, and I can explain why.
Bag? What was found in that bag? That
$400,000 was found in that bag.
And when they found what was inside that bag, what did they find on your client's person at the time?
I believe they found some cash.
How much in cash?
$9,000, I believe.
Is that something that people normally walk around the city with in their pockets? $9,000 and a bag with $400,000?
Your Honor, I would say, though, however, the evidence in this case makes quite clear that Mr. Rich was a person who ran a lot of sort of ordinary errands for Mr. Alvarez. He took his dry cleaning to his house. He took his girlfriend to look at an apartment. He went to Jimmy John's for him. The same night that he...
Did he also drive him around from time to time?
Yeah, and he drove him around from time to time. They were friends.
And this when Mr. Alvarez was also engaging in acts that were in furtherance of the conspiracy, correct?
Not at the time Mr. Rich is driving him around, of course. Again, the evidence of Mr. Rich driving around is completely innocuous. They go to the mall. They hang out around Mr. Rich's apartment where he lives with his parents because him and Mr. Alvarez grew up together and lived in the same neighborhood. Yes.
Judge Singh, wasn't the defendant the driver at the IHOP?
He drove the car, parked it on, yes, but that, of course, he's acquitted of everything related to that charge. So I don't believe that.
But the issue is whether he was just there were passive actions by him, or was he? Was there something that we can infer there was a conspiracy?
Well, I
does that factor go to that? Second, there was testimony of unusual actions taken where there's constant switching of vehicles, going around in a small area to see if people are being tailed. Isn't that also evidence of maybe a conspiracy to engage in the sale of drugs?
Two responses. So the first question as to the sale that happened at the IHOP parking lot. I don't believe this court can consider that. Mr. Rich is acquitted of the sale of possession charges, which means he's acquitted of having any knowledge that the drugs were in the car or any intent to sell them. So it can't be used as evidence that he intended to enter into a conspiracy to sell drugs or possess drugs. There's just no way it has any value. Now, as to the other question about the sort of whatever they call evasive behavior with cars, Mr. Rich, actually, there's no testimony that he engages in that activity. There are other people driving that run through red lights, stop the car and tell the police to stop following them, things of that nature. Mr. Rich, once they say he drives in loops, but actually he stopped to pick up dry cleaning and then went to a Jimmy John. So he's actually running errands at the time he's doing that. Now, back to the bag of money that Justice Mendez asked about. I want to make clear that the evidence in the case needs to be interpreted in light of all the other evidence. That is how reasonable inferences are made. If Mr. Rich is largely engaging in innocuous behavior throughout the case and running small errands for a lifelong friend, then it makes pretty good sense he could come and say, hey, here's your dry cleaning. And Angel Alvarez says, hey, take this bag back to my apartment for me. And Mr. Rich says, okay. It requires no inference that he knows what's in the bag. And then when you interpret that in light of the rest of the evidence, there's 2 years of surveillance in this case. Rich is present on 8 days total. On the vast majority of those days, he does nothing that has any probative value with regards to a conspiracy. And
Counsel, if I may, this is Justice Kennedy. What about the evidence that Alvarez provided your client with his password? He had texted the password to your client, and certainly the detective, it was Detective Hernandez, I believe, had testified that members of gangs, particularly with drug selling organizations, they regularly provide their messages to avoid detection. What about that part of
So I think there's 2 responses to that, Your Honor. One of them is that the prosecution never established that it was, in fact, a password to an email account. People's email addresses are often the usernames for numerous different kinds of accounts. We have no idea what.
Angel155
at gmail.com.
The Gmail, and
That's right.
also texted Angel155 password along with his Gmail address to defendant.
That's correct. And like I'm saying, though, people's email addresses are often also their usernames for numerous accounts across the internet. We have no idea what that information pertained to. It could have pertained to the Hertz account that he also texted him a picture of his gold card for that at one point, too, assuming Mr. Rich was allowed to use it occasionally. The next point is with regards
also to avoid detection as well. That could be another possibility. Am I right?
I guess it could be, but it would be based solely on the testimony of Detective Hernandez. And that's the next point I want to make, which is that ultimately the prosecution's case boils down to the testimony of this expert, because otherwise the vast majority of the evidence is susceptible to innocent explanation. Actually, we think all the evidence is susceptible to innocent explanation. So what the prosecution does is call a police officer who they then state the facts of the case to and then ask him, is this indicative of a drug trafficking organization? And then he says yes. That right there, a lay jury is going to be overwhelmingly swayed. And that's why this court's review power is so important here, because this court sees criminal cases every day and knows that we can't convict someone of conspiracy solely on the say-so of a cop who comes into court as an expert and is told the facts of the case and then repeats back, yes, that means he's guilty. That is not competent evidence of a conspiracy, and there is no case in the state that says a conspiracy liability can be made out solely on the basis of an expert. Otherwise, the rest of this evidence in this case shows that Mr. Rich was Mr. Alvarez's friend, and maybe it was a bad choice for him to be friends with him and ride around in his cars, but that does not prove that he had the knowledge or the intent to enter into the conspiracy. Now, if I may, go ahead, Your Honor.
Can you save your point for rebuttal?
Yes, I wanted to address sentencing in rebuttal if I could.
All right, why don't you do that in rebuttal? Ms. Friedman, on behalf of the District Attorney's Office.
Hi, yes. Can you hear me now?
Yes. Go right ahead.
Good afternoon, Your Honors. My name is Ellen Friedman, representing the people. Your Honors, there was overwhelming evidence in this case that the defendant played a key role in the cocaine trafficking conspiracy led by Alvarez. And the evidence couldn't have been clearer that he acted in a coordinated manner with him and the other members of the organization to achieve the common goal of possessing and selling large quantities of cocaine. The thing I want to start with is that in August of 2012, he walked out of Alvarez's apartment containing a bag with $400,000 in it, had another $9,000 on him when he was later arrested. that the kingpin of a conspiracy would trust him to transport almost $500,000 in proceeds itself shows that he was part of the conspiracy. It's just not the kind of responsibility that would be given to somebody who was a childhood friend, who didn't know what was going on, who could be robbed, who could be stopped by the police without knowing how to handle that. Secondly, on another date, he left his apartment carrying a stack of money that was wrapped in brown paper, the way that money in proceeds is often bundled. Alvarez was nearby, seated in the driver's seat of his parked car at the time. And again, a couple months after that, it was, regardless of the fact that the defendant was ultimately acquitted for whatever reason of participating in the drug sale, the fact that he transported Alvarez himself, as well as a kilogram of cocaine to the location of a prearranged drug sale, certainly showed that he was a central player in the conspiracy and did have that intent. Beyond that, he certainly participated in what can only be interpreted as steps to conduct drug sales. Over the course of the investigation, they were observed driving together, circling, dropping off cars, switching cars, talking to a group in a way that indicated a drug transaction was taking place.
Counselor, can we consider what happened at the IHOP?
I believe so, Your Honor. I don't know why the jury found what it found in regard to the sale, but whether he participated in the conspiracy was a different question. There was video surveillance as well as testimony showing that he is the one who drove Alvarez to the location of the prearranged drug sale and drove the kilo of cocaine. Certainly that, along with the other evidence that I'm talking about today, indicates that he was acting in a coordinated manner with the others in the organization to achieve that goal of selling cocaine. I think another important point is that, as Justice Kennedy raised, when executing the search warrant, the police recovered multiple cell phones that not only had pictures of him with Alvarez, with members of the conspiracy, pictures of drugs and money, but it also had that text of Alvarez's Gmail address and password, which is a common tactic used among conspiracy members so that they can share information without creating a record, the record that's created when an email is actually sent. Since my opposing counsel said that he would talk about sentencing in his rebuttal, I just want to raise for a minute while I still have time that despite the fact that his sentence was much closer to the minimum than the maximum authorized sentence, the defendant claims that the sentence should be reduced to the minimum, which is just not appropriate in a case like this, where over 2 years he played such a crucial role in the conspiracy, and he had a particularly violent criminal history, convicted of attempted gang assault where 3 people were stabbed in a parking garage in Manhattan. Took advantage of the sentencing leniency there. He ended up taking a plea and receiving 5 years probation, and he committed acts in furtherance of this conspiracy while he was still on that probation. So the 6 to 12-year sentence was entirely appropriate there. If there are no further questions, Your Honors, I'd like to rest on my briefs.
That would be fine. Thank you very much. Counsel, you have 2 minutes to bring up any points on sentencing or whatever else you'd like.
As to sentencing, Your Honor, I think the most important thing to point out here is that Mr. Rich actually received roughly the same amount or slightly less time in prison than Angel Alvarez, the kingpin of this organization himself, who received 15 years while pleading guilty to multiple counts of operating as a major trafficker. Mr. Alvarez's second in command, Ralph Bencato, received 12 and a half years in prison, only a half year more than the maximum Mr. Rich received. Respondent claims that Mr. Rich is a key player, but I don't think that is something that can be said with a straight face, given the evidence in this case. Again,
did Mr. Alvarez pleaded guilty?
Yes, but of course, Mr. Rich
went to trial.
Yes, but you can't be penalized for going to trial, Your Honor. If that's the only thing separating them.
I totally agree with you.
Mr. Rich, I think even if this court does not reverse his conviction, I think it could, we argue he was not a player in the conspiracy, but even if this court believes he was, certainly it can only be said that he was a very minor player. 2 years of surveillance, only seen on 8 days. The vast majority of the days he's doing little more than driving a car. The people that actually executed the drug deal in the iHeart parking lot, Carlos Laureano received 7 years. Fred Scott received 1 to 3 years in prison. Mr. Rich gets 6 to 12. It's hard to see why that happened beyond the fact that he exercised his right to go to trial. 4 4 to 9 years still incorporates his prior felony. He will be punished for that no matter what, and it's still going to be more than some of the people who executed the large-scale drug deal. The last point I want to make is the respondent's point about him carrying a stack of money is not an accurate statement of the record. The cop said he had a paper bag on him that was money-shaped. That we don't really know what that even is supposed to mean. Of course, the cop does not actually know if there's money in the bag. So there is actually no evidence that he was carrying money. And so I also want to point out finally that respondents' arguments about coordinated activities is respondents' own gloss on the fact that they did not have evidence in this case. Again, there are no recordings here. The vast majority of conspiracy cases, there are eavesdropping warrants. There's some words on record to show that they were conducting drug trafficking organizations. This is just men hanging out in Harlem. And then other evidence of Angel Alvarez committing crimes. That is not enough to convict someone of a conspiracy, Your Honors. So if there are no further questions, thank you and have a good day.
Thank you both very much for your argument. We'll take another look. I see that I skipped over global versus longevity. I believe just the respondent longevity was going to argue, so I'm sorry about that, Ms. Koo. I only missed it by one case, so well, certainly you have 5 minutes to argue.
Thank you, Your Honor.
Thank you.
May it please the court, my name is Jimin Koo. I'm representing Longevity Medical, the defendant respondent. I'm from law offices of Melissa Betancourt. I was not aware that I was going to be the only person arguing today, so I would just like to highlight a quick few points, and the remainder of the time, I'll leave it up to any questions that you may have for me. The points that I would like to make is that plaintiff moved for summary judgment when they were clearly not ready, and they relied on hearsay affidavits instead of actual documents and videotape recordings subsequently obtained that was readily available and in existence at the time defendant filed for summary judgment. And plaintiff was well aware of the existence because in their motion papers, the attorney affidavit in the initial summary judgment, which is attached to their motion appellant brief, it's on page 154 through 182. Paragraph 69, the handling attorney attests to the existence of and actually gives a synopsis of the contents of the video recording. Furthermore, Your Honor,
Counselor,
yes.
This is Judge Singh. I understand the argument you're making. Essentially, they're getting a second bite at the apple, but you know, renewal is renewal. So the question is was it an abuse to not to consider, abuse of discretion not to consider on renewal the evidence, although the facts are already in existence? Isn't there a case law in this department that allows a court to do that even though the facts are already in existence? And it's really a case-by-case determination.
Well, Your Honor, so in the renewal part, there's a total of 3 prongs in which the plaintiff failed let me rephrase. Pursuant to CPLR 2221, they had 3 burdens in which they failed to meet the last 2. That there is new evidence, which there wasn't. All the evidence that they are alleging have been discussed based on the affidavit provided.
But counsel, didn't Judge Singh just said, we understand that, but isn't there a case law in the First Department that says that we have discretion to grant renewal in the interest of justice, even upon facts that were known to the movement at the time the original motion was made? I mean, these facts, he knew that there was some information, but I think there were subpoenas that were issued and lots of information came back unanticipated. So much would go back, and wouldn't a court in the interest of justice want to take a look at that if there was so much there?
If the plaintiff actually gave a reasonable excuse as to why there was a holdup, if there was a fight, or if the evidence was truly lost or elusive, or there was no no cooperation between the district attorney's office or
Well,
the
again,
NYPD.
I'm not sure that the case law requires the standard that you're enunciating. I think the case law gives the courts a little bit of discretion, as Judge Singh also said, on a case-by-case basis to consider newly produced evidence, even if it may have been in existence.
And counsel, if I may, this is Justice Kennedy. I mean, certainly the facts were in existence, but you needed time to gather the subpoenaed records to engage in motion practice. So I want to go to another area, because once they have the subpoenaed records, which includes the videotape confession, and now you have statements from 4 persons saying that they engaged in a scheme to stage the accident, as well as 2 confessions, insurance fraud. Davis pled guilty to insurance fraud, kneeling criminal mischief in connection with the accident. My question is, all of these new facts, wouldn't that have changed the prior determination?
No, Your Honor. All the evidence that were submitted were uncertified and unauthenticated, and so therefore it was all inadmissible hearsay that could not be considered by.
But the evidence was obtained by a subpoena. Was it a court-ordered subpoena?
No. Well, the court-ordered subpoena was only provided to the NYPD. My understanding was that there was a subpoena or a discussion that happened via email with the district court attorney's office, in which they waived their right for CPLR. I believe it was. I'm sorry. One moment, please.
And while you're looking, I mean, weren't some of the statements that were made by the parties admissible as party admissions?
No, Your Honor. Well, the EUO the EUO transcripts that were submitted were uncertified, Your Honor. It came back unsigned. Plaintiff failed to attach any proof of mailing that they reached out to the assigner to get the signature for certification. So these are uncertified, unauthenticated documents for the EUO statements. And even if you were to consider the EUO documents as well as the confessions or the investigative reports, there's conflicting statements that are made in both. And in the very least, it's a tribal issue of fact, Your Honor, even if the lower court judge denied their motion.
I'm sorry, what is the tribal issue of fact here?
The tribal issue of fact as to whether or not this was a stage fraud, because the EUO transcript.
Based on the evidence that my colleague just recited to you in terms of the confessions and the various statements, the various pleas taken by folks?
The confession was not signed by the police officer, nor was there any foundation or authentications raised. It was uncertified, Your Honor.
What about the pleas? What about the pleas? There were some pleas in this case, right? To insurance fraud?
Based on the submission, I don't know. It's unclear whether or not the plea deals were communicated, whether or not it was accepted, or whether or not this was just a plea deal in the making. I only represent longevity, Your Honor, and I only represent the assigner, Roland Davis, and I did not see any acceptance of a plea deal. I know there is one in existence, but I am not sure, based on the evidence submitted, whether or not it was offered or even accepted or negotiated by the assigner. So in the very least, again, Your Honor, there's a question of fact.
Well, if I may, I want to go to another area, because certainly with respect to the records from DFS and the police department, they bore an electronic signature. So they were admissible under technology law 304 subdivision 2 and 306, no?
No, Your Honor, there's actually case law. I'm sorry, one moment, please.
And while you're looking, it's my understanding that the subpoenas were issued after motion practice.
They were issued actually in 2017. The initial summary judgment motion was made, I believe, 2015. So almost more than a year after did they decide to move for the subpoenas, Your Honor. And again, there was no pushback, there was no fight or non-cooperation from the parties that was requested these documents from. And in fact, they complied via email on the same day. And they could have easily made the motion for the subpoenas or asked for, extension of time. And again, the accident happened back in April 4th, 2014. This is an issue of contract. They had 6 years statute of limitations to bring in a summary judgment motion. They had plenty of time to collect this evidence, and they give no reason as to why they waited until after the fact. And this is, again, their second bite at the apple.
All right. You want to finish up because we've now given you 10 minutes when we said we were going to give you 5. I realized that the judges had a lot of questions, and in that, then we let it go. So anything else? Otherwise, I think we need to finish it up.
No, I have nothing further, and I'll rest on my briefs, Your Honor.
Rest of the judges, okay? They've answered your questions. She's answered your questions. Okay, thank you very much, Ms. Koo. Sorry for missing you before. The next case, I believe, is Ovalle versus Buchwald.
Yes, good afternoon. May it please the court. My name is Joel Celso, arguing on behalf of the appellant, Osvaldo Ovalle. Your Honors, this case involves my client's labor law 241-6 claim, which was dismissed based upon what we believe was the trial court's misapplication of the homeowner's exemption to a property that really doesn't qualify. In our view, the court made a couple of critical errors in both its review of the evidence and in the application of governing law. There is only one case, and one single case that I'm aware of from the appellate division, dealing with a property that is almost identical in both composition and use to the respondent's property in this case. The property at issue, if you're not familiar, it's a 4-story townhome in Brooklyn. Thank you, Your Honor. Our position is that the Acevedo decision should have been followed by this court. And rather than doing so, the court just bypassed the Acevedo decision altogether.
Counselor,
yes.
This is Judge Singh. There's Court of Appeals case law in this area, and the Kayla case, for example, we're supposed to look at the site and purpose of the construction. So let's go over the facts here. There's no question there's commercial use going on in this building. But with respect to the precise construction going on, was that for the benefit of the commercial use or the residential use, or do you say it makes no difference?
Yeah, our position is that it makes no difference. And really where that comes from is the Acevedo court. That was precisely the argument put forth by the defendant in Acevedo. And the court said, listen, we're not going to call this a 1 or 2 family dwelling, so you don't get to the site and purpose test. And they didn't necessarily distinguish precisely why they made the determination that it wasn't a 1 or 2 family dwelling. But what they did make it clear was the fact that there were as many or more commercial uses in that building, they would not go there. And so they said the site and purpose test, we're not going to apply it at all. And in that case, had they applied the site and purpose test, just like in this case, the plaintiff's claim would have been dismissed. But the court said, no, we're not going to go there. And in our view, given that the building and the uses are identical, the Acevedo decision controls. And if Your Honor don't have any questions, I'll just continue to move on. I think it's pretty clear from the Court of Appeals, too, that the homeowner's exemption is to be narrowly construed. And the courts have been really, really clear in terms of saying, if it's a debatable issue or if it's even close, all doubt should be construed in favor of the general rule.
Okay, so how is it debatable in this case? Counselor, how is it debatable in this case? There's commercial use going on, but clearly everything that the construction is for the residential use of the premises. What's the debate?
Well, the debate, Your Honor, is that this is primarily a commercial property. It's primarily commercial in nature.
How is it primarily a commercial property? Because the second and third floors is where Miss Buckwalter has lived for many, many years. She has a 2-floor house, that's where she resides. And then there's a couple that lives on the top floor. So 3 floors are completely residential. Miss Buckwalter also is a psychologist and uses one of the commercial offices, and then she rents out sometimes another little commercial space. So how's that mostly commercial? It seems to me it's mostly residential.
Well, yes, she is a resident there, but she's making rental income off of the 3rd floor with tenants who have been there since 1969. You've got 2 businesses on the ground floor, her own psychotherapy business, which is income generating for her. And then you've got another psychotherapy office on the ground floor, which is not only rented out to another psychotherapist, but then that psychotherapist subleases it out to other psychotherapists. So that other psychotherapist is also collecting rental income. And those other psychotherapists are then collecting income from their clients who are then meeting in that space. So you've got 3 separate income generating uses for the property. It's precisely the same as Acevedo, where the court said we're not going to apply the exemption here because it would not further the statutory aim.
Okay. Any other questions? All right, counsel, you'll have 2 minutes for rebuttal after the other Ms. Buckwalter's counsel speaks, okay?
Thank you, Your Honor.
Thank you. May I hear from you, please? Ms. Shapiro?
Yes, Your Honor. Good afternoon. Madeline Shapiro appearing for respondent Jane F. Buckwalter. Your Honor, the Honorable Elizabeth Gonzalez properly dismissed plaintiff's complaint as against Ms. Buckwalter on the grounds that her 2-family dwelling was eligible for the homeowner's exemption to labor law. Ms. Buckwalter, who has owned and resided in her landmarked 2-family Brooklyn brownstone since 1969, is precisely the type of homeowner that the legislature envisioned in carving out an exemptability. Respondent Ms. Buckwalter satisfied her burden on summary judgment, demonstrating 1, that the brownstone is a dwelling for only 2 families, 2, that the work, demolition, and construction of a porch on the back of her kitchen was an extension of her unit and was entirely for a residential purpose, 3, the presence of her home office in the basement does not remove the premises from the exemption or disqualify it as a 2-family dwelling, and 4, that Ms. Buckwalter did not supervise, direct, or control the work at her 2-family dwelling.
What about what counsel said that she's getting income, so it's income producing, like a commercial, benefit for her, that she has the tenants upstairs, and also that she uses an office downstairs for herself and somebody else uses it, and I think she gets some rent from that. So does that take away from the residential status of this brownstone and confuse the issue so that at least there's an issue of fact, as you suggest?
No, Your Honor, and a dwelling by definition can contain a non-residential portion or a mixed use, which is exactly why the Court of Appeals and the First Department employed the site and purpose test. And the standard, and not only does Ms. Buckwalter primarily use the brownstone as her residence, the standard is not whether she primarily uses it as a commercial property. In cases where the homeowner's exemption was not applied.
Well, yeah, why don't you discuss Acevedo, because that's what your adversary relies on.
Sure. In Acevedo, which is a Second Department case, which I agree is a very tricky and probably a poorly worded decision, because it appears to say that
it's a good thing it's not ours, you're calling badly worded, right?
It does appear to say, Your Honors, that a 3rd unit removes the premises from the homeowner's exemption. But that's not consistent with the Court of Appeals or the First Department or the labor law statute itself, which exempts property owners of 1 to 2 family dwellings from liability. And a dwelling, by definition, can include a mixed use. So to confuse the number of, quote, units, as Acevedo does, with the number of families or dwellings simply just does not comport with the Court of Appeals. And a dwelling, by definition, can include mixed space. And in addition, if you look closely at the evidence and the facts in Acevedo, which I believe were discussed more fully in the Kings County Supreme Court case on appeal, which was citation 35 Miss 3D 1222A, it becomes clear that the owner's intention in that case in changing the building from a 3-residence with a store on the ground floor into a 2-residence, 2-duplex unit with the store was for an economical or a business purpose. At the time of plaintiff's accident in Acevedo, and if you look through page 2 or 3 of that decision, it discusses the facts in detail. At the time of plaintiff's accident, in which he fell from a ladder inside the building, which was gutted at the time, the building was in the process of being entirely gut renovated, converted from a 3-family dwelling, each with 3 separate entrances, with a retail store on the ground level, also with its own separate entrance, into 2 separate duplexes, including the retail store and the addition of a 5th floor. And a close reading of that action, drawing your attention to page 3, says that the property owner, quote, Mr. Woodward changed the premises from a 3 to 2 apartments because if it had remained a 3-story apartment dwelling with a commercial floor space, he would have been required to install, among other things, a commercial elevator, a sprinkler system, a fire escape. He did not have to install these appurtenances after renovation because the DOB classified the premises as a single-family or 2-family dwelling with a store zoning. So although the wording of Acevedo in the second department case does not appear to reach the site and purpose test, the premises in Acevedo would never pass that test. And the site and purpose test employed in mixed-use cases is employed on the basis of the homeowner's intentions at the time of the injury. And unlike in Acevedo, in our case, there's no question that at all times the brownstone was a 2-family dwelling. No more than 2 families ever lived there. There was a shared entrance to the brownstone with a home doctor's office, and that the work in question, the construction of the porch on the kitchen, was only ever for Mrs. Buckwalter's residential use of the apartment.
Okay, anything further?
Yeah, briefly in rebuttal.
Do any of the judges have anything further? Okay, thank you very much, Ms. Shapiro. We appreciate that. Do you have any rebuttal?
I do. So the distinction that Ms. Shapiro makes, I think she's citing from the trial court decision in Acevedo, but the appellate division didn't rely on any of the facts and didn't even discuss them. In fact, they're not even in the appellate decision. All the appellate decision, all that the court really cared about was the fact that you have a ground floor entity that's commercial, that's producing rental income for the owner, and you have 2 residential units, one which is being rented out. And the court said that's enough to take this outside of being a 1 or 2 family dwelling. It's a 3-unit building. We're not gonna call this a 1 or 2 family dwelling. And in this situation, the building is identical. There really is no distinguishable difference. And in fact, in this case, there are more income generating uses in the respondent's building than there were in Acevedo. Finally, and just briefly, the Court of Appeals, as well as the First Department, have made it really clear that the purpose of the homeowner's exemption was really to protect unsophisticated homeowners who didn't have the wherewithal to insure themselves against liability. And that's certainly not the case here. The undisputed facts in the record here were that the respondent, in fact, she contracted with the appellant's employer to insure herself against liability out of this project. And in fact, in the same decision in which the court decided the homeowner's exemption issue, she also decided, the judge also decided that the appellant's employer did in fact breach that contract and had to indemnify the respondent. So this is not the type of unsophisticated homeowner who didn't have the knowledge to go and insure herself against liability. And that's just another point indicating that this is just not the case for the homeowner's exemption to be applied.
Okay. Thank you both very much for the argument. We do appreciate it. We'll take another look. All right. The next case, I believe, is People versus Francis.
Hello again, Your Honor. Stephen Strother,
Hello
Office
again.
of the Appellate Defender, on behalf of Quindell Francis. Quindell's justification defense was fatally undermined by two critical errors in this case. First, the court's justification charge violated this court's decisions in People v. Velez and those following. And second, the prosecution was allowed to elicit that Quindell was associated with the Bloods gang, even though Quindell was not ever affiliated with that gang, and the prosecution knew that to be true. To begin with the Velez point, this case is indistinguishable from the 15 prior cases where this court has reversed under Velez, where the court issues the old CJI instruction and, yes, Your Honor?
Counselor, are we sort of moving away from that? Because the most recent cases from the appellate division seem to be suggesting to be more careful with use of our interested justice jurisdiction.
So I want to make
issues.
There are two recent cases where this court has declined to reach in the interest of justice, but those cases are distinguishable for two reasons. First, they post-date Velez, where counsel is on notice of that decision and knows how to object. In Davis, one of the recent cases, counsel explicitly said this charge satisfies Velez, and then it was raised on appeal. In Macon, the charge itself satisfied Velez, so it wasn't really an issue. The judge in that case told the jury, don't deliberate if you acquit on the top charge on the basis of justification. That satisfies Velez. So this charge in this case is the old CJI charge that was invalidated over and over again.
This is an old trial. This is a trial from over 10 years ago, right?
Well, yes, but as we explained in our reply brief, the cases, the circumstances in this case are truly extraordinary. Quindell hired David Siegel, an attorney this court has suspended more than once. He used his entire inheritance to hire him. Mr. Siegel never filed a brief, never told Quindell that he had been suspended from the practice of law. And then when Quindell did find out that he had been suspended, Mr. Siegel tried to send him a brief that was 21 pages with 2 case citations. Quindell then moved for poor person relief. We were assigned, and our brief was timely filed. Quindell has been prejudiced severely by this. He's been incarcerated for 15 years now. It would be unfair for him to not have his conviction reversed for this clear error that's been outlined in 15 other cases solely because David Siegel was incapable of doing his job. And I would also like to point out on the issue about the redirect of Stephen Jimenez. In this situation, the prosecution said they had to bring out the fact that Quindell's friends were Bloods members. However, the NYPD had already investigated and shown that Quindell was not a Bloods member. The prosecution knew this. The DA told the trial judge, the first trial judge, a different judge than the one that presided over this trial, that she knew Quindell was not a gang member. She could not prove that he was, and that they believed this incident had no relationship to gang activity. Changes tacks at the third trial when it's time to admit this evidence. However, the courts suggested a compromise here. It said if Stephen's state of mind needs to be clarified, he could say Quindell's friends and I got in fights at school, and that's why I was wary of him. He says, why is that not enough? The prosecutor says, well, it has to be that they were Bloods members, or otherwise the jury will think that there's a socioeconomic crisis or they don't like each other on the basis of race. These justifications are invented out of whole cloth. There is no evidence in the record. I'm not actually sure what socioeconomic crisis even means in this context, actually. There's no indication that they had any jealousy of one another over money or status. And there's no indication that they had a problem with each other on the basis of race. These were speculative parades of horribles. That's what the prosecution put out. The judge accepted it and allowed the testimony. Overwhelmingly prejudicial testimony that was unnecessary to close any door that may have been opened. As we point out.
What about the issue about the metal pipe? That was found at some point by the investigators.
So the lead detective, Richie Ramos, who incidentally didn't testify at trial, was the person who went and recovered the metal pipe from the scene. Quindell said that he thought it was a stick. However, it was established at trial the lighting was very poor out there, so you couldn't really see that well. And then Brian Rosario said at the first trial and admitted at the third trial that this was the truth, that he also saw Fernando carrying something in his hand. It was a stick as well. Quindell actually said a bat. And then they recovered this pipe right where Fernando's body would have been standing, according to the testimony. So there's certainly a weapon there that fits what Quindell's narrative said it was. So we just want to point out that the reason this court has to take this this testimony seriously is because, as studies have shown, introduction of any information about gang activity increases the likelihood of guilty verdicts by 66%. This is uniquely prejudicial, unlike really any other evidence. And if that's the case, then it really must be completely necessary to bring it in. But here, the only difference between Stephen Jimenez's cross-examination and redirect, cross-examination, he says, we had problems with his friends at school. On redirect, he says, I had fights with his friends at school and they were Bloods members. The only new information is that they're Bloods members. That's not a relevant fact for this trial. It says nothing about whether Quindell was guilty of this crime. And it doesn't really even illuminate Stephen Jimenez's state of mind in a way that helps the jury understand his testimony any more than just saying, I had fights with his friends at school. Overwhelmingly prejudicial information for no reason. And if I may turn to Quindell's sentence, unless there are other questions on these issues.
Yeah, actually, I do have a question, Counselor.
Yes.
Going back to the Velez issue,
Yes.
Could it be argued that the error was harmless?
I don't believe so, Your Honor.
That turns on justification. So why do you believe it wasn't harmless here?
Well, I think I'll say that it's laid out in our brief and our way to the evidence point, but I want to say that the evidence in this case largely supported Quindell's narrative. One of the prosecution's eyewitnesses said Fernando was carrying an object that looked a lot like that metal pipe that's recovered.
Okay, but your guy had a gun. He
Yes.
says that the gun apparently fell once. Maybe that hit him, but there were, I think, 7 shots fired. Correct? So,
That's correct.
So what about the other 6 shots? If one was
I'm sorry, Your Honor. Keep
Go ahead.
I apologize. As we point out in our brief, there are 7 shots fired, but actually they only find 2 bullets at the scene and 3 shell casings, which indicates, if you look at the photos we've submitted to the court, that he was firing so wildly that he must have missed the house or the entire scene, which fits with his statement that he was running away and firing wildly in fear after the bat had been swung at him.
You mean he's running away and firing? I mean,
But he's also missing with the vast majority of those shots, of course. That's why they're not found at the scene. They only find shell casings from 3 of the shots. So it supports his narrative that he swung the bat at him and ran away after he fired the gun and then ran away, firing wildly behind him as he left.
But what about that shot that I think it was the medical examiner said must have been shot while he was looking over his left shoulder, and, they wasn't sure how much the distance was. I mean, I'm not sure that's a wildly fired shot or something that could have happened when he dropped the gun. It had to have been above him. So and that seems to have been the fatal shot based upon the testimony at trial. So how do you explain that?
So I want to say that the medical examiner didn't say that it must have been that way. He said it was consistent with, but it's also said on cross it was consistent with him facing Quindell while he was turning away from him. So if you see it from Quindell's point of view, he's swinging the bat at him and then starts to turn away and gets shot in the neck as he's turning away. And then Quindell starts to run away and keeps firing the gun. My point here is that the evidence can be read to support Quindell's narrative just as much as it can be read to support the prosecution's narrative. If that's the case, they haven't disproven the justification defense beyond a reasonable doubt. That's the prosecution's burden. If that's the case,
Counselor, if I may, because your client also said that Fernando stated, "Get back." So we don't know if it's a bat, if it's a stick, it's a pipe. Certainly a pipe was recovered, but you have conflicting evidence with respect to if it was a bat, if it was a pipe. It was a stick, but one thing is clear, that Fernando said to your client, "Get back." Your client said this. So doesn't that cut against this justification that Fernando was in fear, he felt threatened when he says to your client, "Get back"?
So if he said to him, "Get back," Quindell is not required to, of course, to get back at that point. He's only required to retreat if he can after he's faced with deadly physical force. If he's coming to him to talk to him, like he said he was going to, and like his mother told him to, and then he walks up to him, he says, "Get back," and Quindell's like, "Hey, wait a minute," and then he starts swinging the bat at him. We have multiple witnesses to say that metal pipe is capable of causing death. We have multiple witnesses. The police say it, the medical examiners say it at trial. At that point, Quindell's entitled to respond with deadly physical force. The point of all this is to say both the conviction was against the weight of the evidence, and also to answer Judge Sing's point that given the sort of equipoise at which the evidence stands, and the fact that this was the third trial, there had been a hung jury in one trial, he was acquitted of the murder count here, there were numerous jury notes in this case, it's certainly the Velez error is not harmless. And if I could be allowed to mention sentencing now or on rebuttal, I'm happy either way.
Why don't you do it on rebuttal, because I've given you about 10 minutes already. Sure. Okay. Thank you very much. Could we hear from the district attorney, please?
Good afternoon. May it please the court. ADA Nicole Nichols for the Office of Darcel B. Clark. Here, I just want to address a factual issue. Defendant appellant counsel insists that the victim was facing the defendant at the time that he was shot in the neck. The medical evidence disproves that, and appellant counsel has not cited to a single page in the record where the victim was facing the defendant. What Dr. Gill said is that if you look at pages 627 of his testimony, 636 and 644, is that the defendant had to be, his back was to the victim's back was to the defendant, that the victim was crouching, looking over his shoulder at the time he was shot in his neck. Similarly, the wound to his lower back, also, he was turned facing defendant at the time he was shot. There was no way that the shot through the neck could have happened with the victim facing the defendant. That fact establishes that defendant was not justified in shooting the victim. The victim could not have been threatening the defendant if his back was to him at the time that he was firing his shots. So, just to start that. But we also believe, Your Honor, that the Velez point, as Your Honor pointed out, it's not preserved and should not be reviewed in the interest of justice.
But Counselor, there's a series of cases we've done it in. It's just really recently we're getting away from it. So really the issue is whether there's overwhelming evidence or not on the issue of justification. Isn't that the issue? And that's what
Yes, and that's what we argued. And here, Your Honor, we believe that there's overwhelming evidence that the defendant was not justified in his action. Let's note that how this event occurred. Defendant himself said he took the gun that he had purchased 2-3 months before this incident. He went to the street looking for the victim after 10 at night. He's looking for the victim, which calls into doubt his assertion that he went to have a conversation with him. I don't believe you maybe would go at 10:30 at night to have a conversation about, quashing a beef. He also followed him down the driveway when he believed the defendant was alone. And he then fired 7 shots that the evidence, if you look at the People's Exhibit 12 and 13, which shows the very concentrated nature of the forensic evidence, suggests that those were 7 deliberate shots that he fired at the 16-year-old victim. And then after that, he fled and discarded his gun. This certainly showed that the defendant acted intentionally and that he wasn't justified. In regard to the stick or the weapon, the evidence at trial was that the witnesses at this trial said that the victim did not have anything in his hand. While one of the witnesses said that at the first trial, he did testify that he believed the victim had a stick or something in his hand. That belief was really based on the sounds that he heard. And he realized that really it was this gunshots. And he thought the victim was hitting his car with something. And that's why he thought he had something in his hand. But at this trial, that witness testified that he did not believe that Fernando had anything in his hand. And to the extent that was a dispute, that issue was presented to the jury, and the jury resolved that factual issue in favor of the people.
Was it error, Counselor, for the court not to charge that the pipe found at the scene was a dangerous instrument?
No, Your Honor, because a dangerous instrument in itself was not an element of these counts. And here the judge gave the justification charge. The judge accepted that there was a possibility that the victim had this this bat or rod that was found in this driveway, that when we looked, there was numerous other, the evidence, the exhibits show that this backyard had these type of metal things strewn around the backyard, that he had this in his hand. And because of that, the judge agreed to give the justification charge. So where the defense got the justification charge, really all the defense was trying to do is shore up that justification charge by getting that per se instruction. But here the court has said that where there's a factual dispute relating to the use of this pipe, and we don't dispute that if the victim had used the pipe, it would be a dangerous instrument. But here we dispute that the victim possessed it, much less even used it. And given that factual dispute, no error.
About the testimony regarding the Bloods gang membership.
Right. Again, I believe appellant misstates the record. The people at no point alleged that the defendant was affiliated with or a member of the gang. We made that clear. Indeed, our witness testified that defendant was friends with the gang, with members of the gang, not that he himself was a member of the gang. So to the extent there was any error, we would say that there was no prejudice because of that. But we would urge here that it was the defense who opened the door to this line of questioning. Our witness on direct consistently said we had problems with Quindell's people, with the people he hung out with. He kept it very vague. However, defense counsel then came in and insisted and said, is it because they're in the projects? Is it the people you had, people with the projects who lived in the projects? Is that the issue? And by doing that, that certainly created an impression that the victim and his friends who lived in private homes may have had an issue with the people who lived in the projects. It certainly could have created a racial impression with the jury because it was clear that the defendant and his friends were African American, whereas the victim was Spanish. These were issues that a jury could, view negatively, and therefore the people should have been allowed to explain why Brian and Stephen would have noticed the defendant on the street at that hour at 10 after 10 at night, why it would have raised his alarm and would have pointed that out to Fernando to say that, hey, the defendant is on the street at 10:30 at night. And to show the jury that this was not, these issues, but really the seriousness of it, that the victim was friends with these individuals. And again, I think it goes to the fact that there was no prejudice because the prosecution did not raise this issue in summation. The only mention of it was that brief mention on redirect. And the judge gave a limited instruction. So we would argue there's no error and there was no prejudice from any prejudice was cured by the court's conduct. And while it wasn't addressed, we'll just address the sentencing issue, Your Honor. We recognize that the defendant was 16 years old and was sentenced to 25 years. However, the nature of this offense here, the fact is the victim was also 16 years old. The victim will not be released in 25 years and their family will not be released in 25 years. The defendant's conduct, as I discussed relating to the weight of the evidence, supports this, substantial sentence. The defendant acted deliberately. He followed this unarmed 16-year-old down the street and fired 7 shots at him, one of which struck him in the neck and killed him in front of his friend's home. Every time his friends exit his home, he has to remember his friend died here. He then fled, discarded the gun, came up with various alibis to try and excuse his conduct. It was only when he learned that there were actually witnesses to his conduct that he then came up with this justification defense. Defendant here, Your Honor, was not acting as an impulsive 16-year-old, but rather acting deliberately and supports the judgment that was, the sentence that was.
Thank you very much, counsel. Mr. Strother, any, I think you said you wanted to address the sentence on rebuttal.
Yes, the sentence and a couple of other things. I'll
Sure,
start
yeah.
with just a point that they made. I'm sorry, I did misspeak about which direction the shots were fired in. It was the second shot, the graze wound, that entered from the front and exited the back, and the next shot from the back to the front. Of course, the point being is that it still supports Quindell's narrative that Fernando's facing him and then turns away from him and gets hit with the second shot. And of course, at that point, Quindell runs away, which is why the shots are fired so wildly. So that point I want to address there. Secondly, I want to point out that the fact of the jury sending numerous notes, the fact that there was a decent amount of evidence to support Quindell's claim, especially Brian Rosario claiming at trial, this is something that I believe my adversary got wrong. Brian Rosario says explicitly, I was telling the truth at the first trial when I said that Fernando was carrying something I thought was a stick in his hand. He says that's the truth. That is the testimony at this trial, not just the first trial. So someone saw him carrying something like what Quindell said he used to attack him with. That's pretty strong evidence that I think right there renders it not harmless in terms of the Velez error. As to the Bloods testimony, I want to say that the idea that just because Stephen didn't say Quindell is a Bloods member, this automatically becomes non-prejudicial is really a stretch. The whole point of saying it is, of course, Quindell now becomes someone who the jury is going to think, if he's affiliated with them, and that's why they're worried about him, and now he's dangerous, oh, he must be a member too.
But wasn't any curative instruction given?
So there's a curative. It's objected to by counsel, and I think the point of our evidence that 66% of verdicts become not guilty to guilty on the basis of gang evidence is that a curative instruction just can't cure the prejudice here.
So what was the court to do then? Just declare a mistrial at that point?
I would say not admit the evidence. That's the whole point. Don't admit the evidence. It was easy. The court said that there was a way to fix this. The court said Stephen could testify that the reason that he was worried about Quindell is because his friends had jumped him at school. There was no reason to mention the Bloods gang. The prosecution's only justification for that was that it was a socioeconomic crisis that was being hinted at, or the jury may think it's about race. These are speculative rationales. They have no basis in the record at all. The court can't allow overwhelmingly prejudicial evidence just to address the prosecution's sort of parade of horribles they come up with during a motion in limine. That's not the way this is supposed to work. It has to actually be necessary to clarify the testimony on cross. The court suggested a way to do it that would have clarified that didn't include this prejudicial information, and instead backed down when the prosecutor raised the specter that this case may be infected by race. That was a cynical strategy, and it worked, but it shouldn't have worked. Now, as to the sentence, a 25-year maximum sentence for a 16-year-old child flies in the face of over a decade's worth of social science research, Supreme Court cases from this state, and actions by our legislature and the legislatures of every state in the country about adolescent sentencing. Adolescents should not be sentenced like adults. We know this now. It's black letter law at this point. That they have reduced culpability based on the fact that they're more likely to make poor decisions under stressful circumstances. Quindell had been threatened by Fernando's father with guns 2 weeks before this case. They had had words in a room together, and there was a lot of violence going on between kids in this neighborhood. It was not a safe neighborhood, as the evidence in this case shows. Even if Your Honors believe that Quindell wasn't justified, it could be, and it's clear that he made some mistakes in this case. It's not the kind of case where a person gets the maximum sentence, even if they were an adult. There were mitigating factors. For respondent to stand here and act like Quindell is some mercenary who tracked this kid down and executed him, that's not even what the jury found in this case. He was acquitted of murder and convicted of manslaughter. And the idea that every time someone is dead, they reserve the maximum sentence, if that was the case, the maximum sentence would be applied to every single manslaughter conviction. But Quindell's a 16-year-old child with no criminal record. The idea that this child deserves to spend the maximum sentence flies in the face of every development in the law. And I believe this court, while this court's not duty-bound to apply that law, it certainly must construe sentences to be fair and in accord with other sentences meted out to people in similar circumstances. circumstances. And throughout this country, 16-year-olds at this point are not getting the maximum sentence, even for violent crimes. We point out in our brief, we cite numerous cases where children have been sentenced to less than the maximum, even for murder convictions, much less manslaughter convictions. Quindell's already served 15 years in prison. This sentence has to be reduced. Thank you, Your Honor. Okay. Thank you both very much for answering all our questions. Have a nice afternoon. Take care. Thank you, thank you both. And the last case for oral argument today is MacArthur versus Fields. You each have 5 minutes. Okay, Mr. Schneider.
Yes, Your Honor. Good afternoon, and may it please the court. I'm Spencer Schneider. I represent MacArthur 1, who's the appellant, cross-respondent, and the judgment creditor. The issue on the main appeal is what are the proper damages to be assessed against a garnishee who violates a restraining notice and has been found in contempt. The motion court found the garnishee in contempt under CPLR 5251, finding that the garnishee had refused to obey a restraining notice. The standard for damages is set forth in Judiciary Law 773, which provides that if an actual loss or injury has been caused to a party to an action or special proceeding by reason of the misconduct of someone else, a fine sufficient to indemnify the aggrieved party must be imposed upon the offender. What does that mean with restraining notices? Well, if the judgment creditor can show that the failure to obey the restraining notice caused actual... Yes, Your Honor. I'm sorry, you're...
Okay.
You're
Go ahead.
I want to go back to the issue of
Yes.
Possession and control.
Sure.
Not possession control, but possession or custody.
Yes, sure.
Keep using control, but I mean custody. So
That's
how is
the
that
problem in this case.
Exactly. Okay. You want me to talk about that, or do you have a
Yes,
specific
I do,
question?
because that's an issue in my mind, at least.
All right, well, let me get to that, and then I'll go back to damages if I have some time. So the respondent claims that they didn't have possession or custody of the bank account. They say the account was not in their names, so they couldn't possibly be liable for what they did. So let's talk about what they did and talk about possession first, because I think you could find them under possession or custody any which way you slice it. FFO had as much possession of the bank account as the judgment debtor. Okay, as you know, they were his agent. They stood in his shoes, and they had express authorization to access his bank account. No different than if any of us right now went online to access someone else's bank account. That's an agent. They were given the security credentials, the passwords, and they, over 62 days, made 67 transactions at the debtor's direction.
Well, that's the question. Was it at the debtor's direction, or could they just go into the account at any time, pay off any bills they chose to pay? Or was the debtor controlling what could be done here?
The debtor told them what to pay. The debtor had given them the bills. The bills also came directly from other creditors of the creditor. He also told them to disperse $115,000 to his family. This is all after they had the restraining notice, Your Honor. I mean, they knew something was up. They had a restraining notice. It went to the general counsel. They had a subpoena, and they had a subpoena, which I was asking for documents to find out where the bank account was. Okay, this is a sophisticated business, and they had a general counsel who got a subpoena and a restraining notice and did nothing. They didn't answer the restraining. They didn't answer the subpoena even. They didn't give us documents, and we didn't know where the bank was until we made a motion to hold them in contempt. Judge Crane gave them a chance to purge. By that time, everything was gone, over $470,000. They also deposited third-party checks into the account that Mr. Fields would give them. They got the statements. So let's talk about possession some more, because there's some issues about whether or not literal possession is required. I'm going to say that even if it were literal possession, they had it, in the sense that they had everything they needed to access that account. They possessed it. But literal possession is not required. The lower court found that the issue is whether or not the debtor would directly benefit from the disposition. And that follows a line of cases that are in the second department and also adopted in this department. And I think, Your Honor,
can you distinguish the defendant relies very strongly on this Commonwealth of North Mariana Islands case, the Court of Appeals case from 2013, where there was perhaps a different relationship, but can you distinguish that, why that would not apply, in your opinion, to this set of facts in this case? Because they went the other way in that case, and it was also, even though it was a different statute, it was still possession or custody versus control.
Right. And I'm saying we have possession, we also have custody, but leaving that aside, that case has nothing to do with this situation. They cited that was a turnover proceeding, and the defendant the court didn't even have jurisdiction over the subsidiary of the main entity. So the court wasn't in any position to order them to do something over this other party. And since control was not part of the statute, they had to have actual possession. And the other big thing there, Judge, is that's a turnover proceeding, Your Honor. That's a different animal than asking someone to not do something. We're saying, don't move this money that you have possession of. We're not asking them to turn it over. But the problem was that they spent it. And the bigger problem, Your Honor, for my client was that they didn't get back what was done wrong to them as a result of the contumacious conduct of FFO.
So you're just one more minute on damages, because you obviously don't agree with the amount of damages that the judge, and you thought that there should be a much $469,000 plus attorney's fees that should be given in this case. And so could you just explain why that, why you think that's the appropriate
Thank you, Judge. Thank you for the opportunity. So what the judge did was, at FFO's urging, she capped the damages at the amount of money that was in the bank account the day that they got it.
Right, that's correct.
Right. But after the restraining notice was when they made the dispositions, which
I guess money came in and went out, obviously.
Exactly. And
is it your argument that there was a continuing violation and therefore you're entitled to damages for the full amount, in essence? Right?
You violate it when you do anything while a restraining notice is in effect, and it's in effect for a year. And 5222 says that it includes after acquired property. The Nardone case, which I cited, also involves something very similar to this, where money was deposited after the restraining notice, and that money, God bless you, and that money was also covered. That money was also to be recovered by the judgment creditor. And I'll tell you, that's also a lower standard in that case, because that was a supplementary proceeding under 5222. Here we had a finding of contempt, and that shouldn't be disturbed, that finding, because of the judge's findings, and I don't believe there was abuse of discretion. So what I'm saying,
finish up.
Okay,
please.
All I'm saying is that the actual damages, which is what the judiciary law requires, is what was actually disposed of during the term of the restraining notice. Thank you, Your Honor.
Thank you very much. Can I hear from counsel for the respondent, please?
Yes, Your Honor. Benjamin Bianco for the respondent, FFO. Mr. Snyder spent a lot of time saying there was possession or custody, but there was the hallmarks of possession or custody aren't here. My client had no responsibility to safeguard this money. My client had no responsibility to do anything other than what it was instructed to do with this money.
But what about when your client was served with a restraining notice? Did they have an obligation to ignore a court's restraining notice that they could do?
Well, no, Your Honor, I don't believe that that's what they did. What they did is look at the notice, and again, I wasn't counsel. This was done presumably by their in-house counsel, but because they didn't have possession or custody of this account, and that they didn't necessarily ignore the restraining notice and didn't ignore it at all. They didn't believe it applied to them because they didn't have possession or custody of the money.
But how do you argue that, counsel? How do you argue that there's no possession or custody when your client actually disperses payments, brings in monies, put monies into the bank account? Isn't that a hallmark of possession, being able to disperse monies?
Well, no, Your Honor, I would respectfully disagree. I believe that is a semblance of control, but my client could not do anything with this money without specific instructions. And again, it's in the briefing, but I think it's important to mention, my client is still owed over $500,000 by Mr. Fields, and my client did not pay itself out of that money. My client still followed the instructions of Mr. Field and paid the obligations that he directed them to pay. If they would have had possession or custody or some ability to make decisions over the account, they could have.
Well, but they had the ability to say, I think the point was already made by one of my colleagues, not to do anything. Didn't they have that ability?
I'm sorry, Your Honor. I don't disagree with you. Of course they could have done that, but they didn't believe this applied to them. And the argument is it didn't apply to them because they did not. Look, the legislature left out control for a reason. And as the court in North Mariana Island says, when the legislature does that, that has to be respected. And you shouldn't read a term that was deliberately left out into another term like custody or possession, so it's covered. I mean, we all have used possession, custody, and control in discovery, terminology. I mean, we all know what that means, and the legislature left it out. And again, it makes sense, because if you think about it, my client had zero discretion over this account. And yes, it had some semblance of control, but it makes sense the legislature leaves that out, because even if my clients did nothing, Mr. Field simply would have went in the account and paid his own bills or transferred it to another account or brought in someone to replace FFO. He had all that ability. It's his account. So
you say that your client didn't have possession or custody, correct? All they did was pay bills from the account, deposit money into the account. What would they have needed to do in order to have had that possession or custody of this account?
As opposed to control, you mean?
As opposed to control.
Right. So, let's look at the two cases cited by Justice Crane. She cites Wimbledon and Ray. In Wimbledon, it was a law firm's escrow account. That's possession or custody, because it's the law firm's escrow account. And when the law firm did not respect the restraining notice, it had the ability to protect those assets. It was essentially its own assets held in escrow for somebody else. So, no one could have come in and taken that. Their clients couldn't have come in and taken out of that account. So we don't believe that particular case is germane here, because, again, it is a custodial account of the law firm. And the same thing in Ray. It was a restaurant.
But it's an escrow account. The law firm doesn't have the right to do anything with that escrow account. It's not its monies. Isn't it similar to this circumstance?
But neither does anyone else, Your Honor, and that's the point, is that if they would have done nothing, yes, that money would still be there because no one else can come in and touch it. But here, the accounts would have been drained. They would have been paid by Mr. Field. It's Mr. Field's account. He had a checkbook. He had whatever else he had, a debit card probably. But he had the ability to move that money wherever he wanted. That's possession and custody. My clients, and admittedly, we admitted all over the brief, they had some semblance of control. But that's not
Counsel, if I may, I want to go to Ray and the other First Department cases that opposing counsel cited in the brief, because in all of those cases, actual possession was not required, unlike the case that you cite, the Commonwealth case. There, it's a turnover proceeding. You needed actual possession to turn over the funds. So can you explain to me how Commonwealth is applicable when we're dealing with a different statute where you need actual possession, as opposed to Ray and the other cases that are more on point here when you don't need actual possession?
Well, it's applicable not necessarily for the specific facts of that case. It's applicable because the Court of Appeals in 2013 recognized that when control is left out of an Article 52 statute, and they did, it was not 5222, but they did reference 5222 as being a similar statute. So when you leave out the term control, it is not the court that it should be reading control into the statute when it's been deliberately left out. And with respect to those other First Department cases, Judge Kennedy, those were the specific issue of whether the restrained party, not the judgment debtor. The judgment debtor, that's very different. The statute talks about the restrained party, in my case, FFO, in this case, FFO, and the court was not looking at control. I'm sorry, strike that. The court was not looking with respect to possession or custody of the judgment debtor. It was of the restrained party. It was looking at exactly the opposite. And that's what Justice Crane cited in her decision. She, in our opinion, with all due respect to Justice Crane, made the mistake of applying those cases and saying, well, just because the judgment debtor didn't have specific custody, the statute still applies. Well, that was not what the issue is. The issue is if the restrained party has custody or possession or custody. So that's where I think those cases are easily distinguishable, and we distinguish most or all of them in the brief, and that's how I would answer your question, Judge Kennedy.
Okay, well, what about the fact that Fields and his family would benefit from the payment of the expenses? What about that?
Again, and that's what Justice Crane said in her decision, but that's not germane to deciding this issue. Yes, he benefited. We're not denying that. Of course he did. He was paying American Express bills. He was sending money to his family. Not germane.
That's the receipt of the restraining notice,
which my client didn't believe applied to it. I mean, that's the crux of this case. My client wasn't deliberately violating a restraining notice and saying, well, I have this restraining notice, but we're going to, their point was it didn't apply to them. And so they didn't believe it applied to that account. Now, if they would have had a custodial account that was in their name, like an escrow account, as Judge Mendez mentioned, if they would have had an escrow account that was Mr. Fields, absolutely the restraining notice applied, just like it did in Wimbledon. When you had a law firm that had a custodial escrow account, absolutely correct, Justice Mendez, they couldn't do, or I believe it was just Judge Singh, couldn't do anything with it without authorization, but it was still in their possession or custody because it's their account. Here, it's not the same case. And in those other cases that Your Honor's mentioning, that is the case. In Ray, it was a restaurant's own account. In Wimbledon, it was a law firm's escrow account. Here, none of those are, that's not the situation we have. We have an entirely different situation.
All right, well, I'm glad that we gave you some time to argue, and I appreciate your answering our questions. You see, we had a lot of them, and we will certainly take a look at the cases that you've both cited. So I thank you both very much. This concludes oral arguments for today, and the court is adjourned. I think everybody has to get off of the Teams meeting on their own. Okay? Thank you all very much.
Thank you, Your Honors. Have a great day.
You too.